All right, that's 9 o'clock. Let's get our meeting started. It looks like everyone is here. So roll call as everyone's here. Approval of the May 13 minutes. Is there a motion to approve? Or are there any corrections or edits to that?
I'll move their approval.
Second.
Motion and second. All in favor signify by saying aye.
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 Aye. All opposed, no. Motion carries. Approval of today's agenda. Is there any corrections or adjustments to our agenda? If not, I would entertain a motion to approve.
So moved.
Second.
Motion and second. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. For the public, just so you know, if you need a copy of today's agenda, you can get it on the back bookshelf, so you can follow along all the items. PJ, consent agenda.
Good morning, Commissioners. PJ Conover, Director, Planning Department. Today's consent agenda. The following items have been placed on the consent agenda for action to be taken on all items in accordance with staff's recommendation by a single vote. Any item may be removed from the consent agenda by any planning commissioner, staff member, or audience member for separate consideration. The findings of the Planning Commission or recommendations to the Pennington County Board of Commissioners will make the final decisions. Item 3, conditional use permit review 1319 for Ken and Gary Tomovic to review a recreational resort to allow events for 20 people or less in a general agriculture district. Staff recommends approval of the extension of conditional use permit 1319 with 16 conditions. Item 4, conditional use permit review 1510 for Krebs Partnership LLC. Donald Krebs is the owner, to review a home occupation on the subject property in which no immediate family members reside, to use a detached garage for the purpose of buying, repairing, and selling vehicles not intended to be a car lot in a suburban residential district. Staff recommends approval of the extension of conditional use permit 1510 with 14 conditions. Item 5, conditional use permit review 1806 for Milber and Lila Rohrbach to review the replacement of an existing single-family or single-wide with a newer single-wide mobile home, number C, it says here, to allow for an existing single-wide mobile home to remain as a storage space, number A, it says, and to allow for the existing double-wide mobile home to remain as a rental unit on the subject property in the suburban residential district. Staff recommends approval of the extension of conditional use permit 1806 with 8 conditions. Item 6, conditional use permit review 1809 for Scott and Christine Grierson to review a recreational vehicle to be used as temporary living quarters on the subject property, which is Lot 6, while building a single-family residence on Lot 5 in a limited agriculture district. Staff recommends approval of the extension of conditional use permit 1809 with 10 conditions. Item 7, conditional use permit review 1810 for Ray and Aaron Atkins to review an accessory structure, which is a garage, prior to a principal structure on the subject property in a limited agriculture district. Staff recommends to continue the review of conditional use permit 1810 to the June 24th, 2019 Planning Commission meeting. Item 8, conditional use permit review 1812 for Idlewise Mountain Lodging. Marshall McCanley as the owner to review a vacation home rental on the subject property in the suburban residential district. Staff recommends approval of the extension of conditional use permit 1812 with 13 conditions. Last 2 items. Item 9, conditional use permit 1908 for Jeffrey Shear to review a recreational vehicle, a camper, while building a single-family residence on the subject property. Staff recommends to continue conditional use permit 1908 to the June 10, 2019 Planning Commission meeting to allow the applicant time to submit a construction permit application to the Planning Department to address dirt work that has been performed on the subject property and to verify that the work is outside the special flood hazard area. Item 10, conditional use permit 1909 for Martina Pugh to allow a single-wide mobile home to be used as a permanent residence in the suburban residential district. Staff recommends approval of conditional use permit 1909 with 7 conditions.
Are there any items that staff would like to have pulled?
No, sir.
Any items for membership to have pulled?
Mr. Chair, number 6, please.
Number 6,
Mr. Chairman, I would like number 8.
8. Any other items for the membership? Any members of the audience like to have any of these items in the consent agenda calendar removed for separate consideration? Currently 6 and 8 are being pulled. Is there any others? Seeing none, that looks like it's going to be our consent agenda for 3 through 5, 7, 9, and 10. If that is correct, I'd entertain a motion to approve those consent agenda items.
I'll move approval of the consent items 3 through 5, 7, and 9, and 10.
I'll second.
Motion and second. All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries.
Thank you.
Item number 6.
Mr. Chair, I don't have any specific questions regarding number 6. This item specifically, more along the lines of, it seems like the board is very lenient to folks building homes and living in these RV things. And so my question for staff is, when these come in as conditional uses, is there a time frame that's typically put on these types of things where they want to come in and live in a temporary camper, that kind of thing? And I don't know who best to answer that question.
Sure. Hi, PJ, you don't have to leave. Oh, get back up here.
You're not out of this one yet.
If they want to do it for an extended period of time, they can't live in more, they could do a conditional use permits. That doesn't mean that they're there 365 days a year. We usually we use the FEMA standard of 180 days, and that's the standard that we put on the RVs.
So they have 180 days they can live in the RV for 180 days out of the year?
Correct.
But it might take them several years to get the structure built, or is there a time frame that it takes for them to get the structure built?
When they apply for the building permit, they have to have it done within 2 years.
Okay.
They have an opportunity for a 1-year extension if they like.
So then if they get an extension, is there additional fee associated with that?
There is. That's
Okay.
correct.
That takes care of admin costs for reviewing the conditional use, et cetera, et cetera?
No, there's no additional fee for the conditional use permit to be extended.
Okay.
There is a $50 fee for the building permit to be extended one time for 1 year.
So they would have 3 years
They
ultimately?
could have 3 years.
Okay. That answers my question. I have no further questions and would move approval on conditional use permit 18-09 for approval with the 10 conditions.
Second.
Motion second. Any further discussion? Seeing none, all in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries.
Thank you.
Item number 8.
Yes, and this is more a question of curiosity. 35 years ago, I managed the Edelweiss Mountain Association, and back then, the owners were very adamantly against, vacation rentals. And I'm just wondering, do we have any idea how many vacation home rentals have now been approved in Edelweiss Mountain?
Cassie Bolstead, Assistant Planning Director. I do not know that off the top of my head. I do know that a large majority of Edelweiss Mountain is vacation home rentals, but I don't know the exact number
Okay.
off the top of my head.
And I'm assuming as I read in the details that notification was sent out and there were no letters of rebuttal indicating that.
Yep.
Yeah, okay. All right, I was just, like I say, it was quite a number of heated discussions 35 years ago that the people who lived there year-round did not want, temporary housing. So, thank you.
I can just follow up on that. Staff met with HOA Executive Board for Edelweiss probably over a year ago, and they
Okay.
expressed some concern about the number of vacation home rentals. Their covenants, as far as we know, does not expressly prohibit them per our ordinance, and they were instructed if they wanted to limit the number of vacation home rentals, that they would have to change their covenants.
Sure, okay. And Virgil Kerstead, is he no longer alive?
Virgil is still alive.
Oh, okay, but he's not actively involved in this anymore?
I think Virgil has sold most of his properties in Edelweiss. I think he might still have 1 or 2, but.
Okay, good. Thank you. Thank you.
Any further questions on this item? If not, Kurt, recommendation is approval of the extension of conditional use permit CU 1812 with the following 13 conditions. Is there a motion?
Also move.
Second.
Motion second. All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries. That takes us to item number 11.
Good morning again, Cassie Bolstead, Assistant Planning Director. Item 11 is layout plat 1910. This is a request to create lots 8A and 8B of Collins Addition. Before I start, I do want to point out there's something kind of confusing on this staff report. On the left-hand side of the staff report in your packet, it says item number 13, and it's actually item number 11. That's just a typo. So the applicant and owner of this one is Brad and Colleen Kurtz. The surveyor is DC Scott. As this property exists today, it is one lot, 10.5 acres, zoned limited agriculture district, access off of Highway 385, and it's currently vacant. What they are proposing to do is create Lot 8A, which would be 3.18 acres, and Lot 8B, which would be 7.32 acres. Neither one of those meet the minimum lot size requirement for a limited agriculture district, so they will have to be rezoned or obtain lot size variances. Access to these would both be off of Highway 385 via a 40-foot shared access easement. This was routed through the inter-department review process. Nothing of significant concern came back. So for the purposes of a layout plat, staff doesn't find any issues with the applicant's request and is recommending approval of layout plat LPL 1910 with 9 conditions.
Any questions for staff?
Mr. Chairman,
Yes,
I
go
just
ahead.
have one question. Is this the property, and it was several months ago that we met on it, that there was a minimum lot size in the area, and this was in conflict with the minimum lot size?
I don't believe so. I think this is a brand new one.
Okay, thank you.
Any further questions for staff? Yes, go ahead.
The easement off of 385, is that an existing easement or will they have to get an easement? Or, I mean, I guess, maybe not the easement so much, but the access off of 385, is that already there?
Um, I don't believe there is an access there already. They're going to have to obtain an approach permit, but through the plat, this little piece right here, you can't really see it, but there's a detail right there that identifies it as a shared approach,
Right.
but they will still have to get the approach approved before they can put it in.
With the state DOT?
Yep.
And the state DOT, I mean, I guess I think about how the DOT is, there's no comments from the DOT on this, is there?
There's not, no.
And I would just, but I guess that's what the layout plat is for, is to, for them to have an opportunity to go and seek out those approvals. Okay, thank you.
Any further questions for staff?
No further
Yes, go ahead,
questions.
Rich.
Mr. Chair, I would just note that it looks like they are combining their shared access off of that entrance on Lot 8A, and then on Lot 8B, there's a non-access easement actually platted or proposed, so it looks like they're going to have to share an access.
Yep. Any other comments or questions? Any members of the audience want to speak on behalf of this item? Seeing none, current recommendation is approval of layout plat 1910 with the following 9 conditions.
So moved.
Second.
Motion and second. Any further discussion? Seeing none, all in favor signify by saying aye.
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 All opposed, no. Motion carries. Item number 12, please.
Thank you. Item 12, this is another layout plat. This is layout plat 1911 and subdivision regulations variance 1904. This is a request to create lot 10, block 3 of the ranch at Black Gap and to waive plating requirements. The applicant is Double L Properties and the surveyor is Spurlet Consulting. This one is kind of an interesting one. As this property exists today, it's within the Ranch at Black Gap planned unit development. It's currently 25.033 acres. Access to it is off of Black Gap Road, and it's currently vacant. What they're proposing to do is not change this lot at all. They're just going to make it a platted lot. Currently, it's an unplatted balance. So they are just proposing to make this a platted lot and put the lot 10 block 3 definition on it. They're also requesting a subdivision regulations variance to waive 2 plating requirements. One is percolation test and soil profile hole information, and the other is improvements to Black Gap Road. Black Gap Road is located within the Ranch at Black Gap Road district, so staff does not see any issues with waiving that plating requirement. However, comments from the county on-site wastewater specialist for this layout plat stated this area has very restrictive soils and natural springs that have caused several septic problems in the past for the residents who live in Black Gap. Staff recommends percolation tests be conducted and a soil profile hole be inspected, just because of those issues that have come up before. Also, the Register of Deeds stated that the located in section of the plat needed to potentially be corrected. She has comments in there of what she believes it should say, which is a comment that is, or a condition that is included as a condition of approval. This one, the reason this one's kind of interesting is because the majority of this property is actually located within the 3 mile plating jurisdiction of the city of Rapid City. There's just a very small chunk right in here that's actually located in the jurisdiction of Pennington County. So they are having to plat this property through both the city and the county. They are having to get approval for that. The Rapid City Community Planning and Development did comment that they're currently reviewing the preliminary subdivision plan for this through the city of Rapid City. They will have to include both certificates and signatures from county and city authorities when they do file this. The applicant does not plan to change density within this subdivision. As I said, the purpose of this plat is to just create one platted lot and eliminate an existing non-transferable balance. So for the purposes of a layout plat, staff doesn't find any significant issues with this request. I do have several different recommendations on this, Mr. Chair. I have two different recommendations for subdivision regulations variance 1904. The first one is that staff recommends approval of the portion of subdivision regulations variance 1904 to waive improvements to Black Gap Road. And the other one is that staff recommends denial of the portion of subdivision regulations variance 1904 to waive percolation tests and soil profile hole information based on comments provided by the county on-site wastewater specialist regarding soils, springs, and septic issues in the area.
Any questions for staff?
Mr. Chairman,
Yes, go ahead, Jim.
so what's your concern about the septic issue? I mean, what actually, I know a lot of those properties out there have had issues, and there are mound systems, if I am correct. So doesn't it simply imply that the owner, should he develop, is going to have to go to some expense in order to do it properly? Or is there an issue that it just can't be done or something like that?
I don't think that there's a definite issue right now. I think the reason that the county on-site wastewater specialist wanted the percolation test and profile hole information done right now is because I believe, if I'm correct, that there are several properties out there that started with a conventional system and then ended up with a mound system. So the percolation test and the profile hole will negate that. It'll just tell you right away if there's springs or bad soils or anything like that, where you'd be looking at a mound system right away.
What you're saying is that the owner, the property developer, would be a fool not to do this, because then he would incur additional expense if he started with a conventional system and just had all kinds of problems that it didn't function properly and he had to do something else.
Sometimes what we see when there's soils in here is that people come in, and I don't know what their plan is for this property, but people come in, they buy it thinking that they'll be able to put a conventional system on it. And then they do the percolation test and profile hole and find out that they can't, and a mound system is significantly more expensive than a conventional system.
Right, so
just
then
to try to
the
negate
question
that.
is, are we obligated somehow to protect someone in the future who might buy this property? Is that what you're suggesting? I mean, that seems like, do we have an obligation to do that? Or should we simply say, buyer beware? You should have known that the first thing you should have done is checked and gotten a perk test and figured out if this was appropriate and so forth. I'm always frustrated by the fact that I think we do have an obligation to do that, but I don't know how many times we've
Waived this.
ignored this.
We've
Yes.
waived it many times.
Many,
That's why.
many, many times, because we say, well, you know, sometimes it's a matter of the soils are generally in the area are pretty good. So it's perhaps a sensible notion that we can ignore this. But in this case, do we have an obligation to alert future buyers that this is potentially a hazard for them? Or should we say, you know, fools, you know, beware, but there are disadvantages to buying property if you don't do due diligence. I'm not sure quite what we should do. I mean, if the person who's getting this platted is going to develop it immediately or soon and not sell it, then it's probably a non-issue. But I think it's frustrating that we don't have some kind of policy that gives us some guidance on this issue, because it comes up as time and time again. So, I mean, I'm looking for a little guidance here, because
Kale from Spurlick is here. Maybe he knows what they're planning to do with this piece of property.
Yeah, thank you. My name's Cale McNabo. I own Spurlick Consulting. I represent the petitioner in this matter. So, yeah, as Cassie pointed out, what we see is a large non-transferable balance, and it's held by Dakota Land and Cattle Company. So it's held in Dakota Land and Cattle, and they want to move it into double L properties. You can't because it's a non-transferable balance. So even though the same owners want to transfer ownership, they want multiple LLCs. They can't right now because it's sitting in a company and it's not platted. You know, I understand the concept behind getting a relatively small lot drilled where you would know where the potential future buildable site is. This is 25 acres. I don't even know where you would begin to want to put a perk test at. This property would not get sold like commercially as 25 acres. I don't know who would take down that big of a parcel. It's subject to re-subdivision. You know, once it gets transferred into double L properties, it would get parted out, you know, further subdivided into either what you see there, the typical residential lots, or bigger. But at that point, you would actually have an idea on what kind of building would go into this property. I mean, they're not going to sell 25 acres and put one house in the middle of it with a drain field.
Right.
There's a long range plan for this, and when it gets further subdivided, I guess it makes sense to me that there'd be some percolation tests done at this point on the 25 acres. This is just solely for the purpose of being able to transfer this within the current holders LLCs.
Any questions?
Yes, Mr.
Yes, go ahead,
Chairman.
Sandy.
And it may have been addressed, but the comment from the Department of Equalization, which indicated the proposed legal, it talked about Black Gap subdivision and the ranch at Black Gap. How was that handled, or
Yeah,
how
we'll
was that
just
addressed?
change the title on the plat to reflect the ranch of Black Gap.
I see, okay. And like I say, it may have been addressed in here, I didn't see.
Yeah, they caught it. It was a typo on the plat, so
Oh,
when
I
we
see.
reissue the plat, we'll just have the
Okay,
correct
thank you.
legal on it.
Any further questions?
Mr. Chair.
Yes, go ahead, Gary.
I was just asking Cassie to make me a little bit more knowledgeable here relative to septic systems and mounds. Are the mounds, are they systems or they're not septic, or they're designed to be pumped?
That is a question that is outside my purview, but Kale designs them.
Yeah, I designed a lot of them in Black Gap. These systems, they come in, you get a perk test result. If they can handle the conventional, then you end up with putting in a conventional infiltrator style system. If the perk tests come back such that you need a mound system, then typically what happens is you build the mound, you come out of the house into the septic tank, come out of the septic tank into well, you call it a wet well, but that's where your pumps sit. And so they'll have a float on there. It gets so deep in your vault, your wet well, and it pumps up there, injects them into the mound system.
And then what happens to it? Is it pumped out of the mound system
No,
then?
it goes up into the mound system, and it basically then perks down into the ground.
Okay.
And the cost difference between those two, just roughly, I mean, I know it all depends. There's a lot of factors, but
On a residential, I think you're looking at around 15,000
for a mound system,
more than a conventional.
15,000 more. That's about what I remember because we were quoted something similar when we were looking at different ones.
Yeah.
Go ahead, Kathy.
I'd like to ask you a question, Kale. Is there, since you've been out there and done a few of these designs and so on, is there significant variation in the soil type, the percolation and so on among those different lots?
Yeah, particularly at Black Gap. And, I've done a number of conventional fields at Black Gap. Yeah, no, they perk great. And then you go across the road and all of a sudden you've got something with a mound on it. You can see it when you drive through Black Gap. You can see the mounds in people's yards, and then you look across the street and there's not one.
I see.
Yeah, the soil variability.
So back to your point then that one has to question the futility of doing one soil test out in 25 or how many acres it is, because you expect anyway that there's going to be enough variability so that once these become smaller lots, then one would still have to do one specific for each lot.
Yeah. Yeah, so if this gets broken down, this 25 acres gets broken down into, say, 25 lots or more, yeah, you'd end up doing a perk test on each one of those lots. And then at that point, you would know where the house is projected to set and where the drain field would feasibly set.
Yeah, okay, thank you.
Any further questions?
Mr. Chair,
Yes, go ahead,
I'm
Rich.
trying to still get back to the second bullet point here and the answer to that question. If the perk tests are required as part of the building permit for commercial building, residential building, et cetera, and we normally are okay waiving this requirement, why was it added again in this instance? I'm trying to understand the specific, why this time on this lot versus if they were going to subdivide it and have homes there, they'd be required to do it prior to the building permit anyway.
Good morning, Brittany Molitor, Environmental Planning Supervisor. I think the concern with the on-site wastewater specialist is the history of systems out there. There's been several conventional systems that have not functioned properly, and they've had to put mounds in. There's several mounds that's had to have new mounds put in. So I think that's a concern out there. We have talked to a soil scientist with some of the soils out there over time as they take on effluent. The structure of the soils change and essentially it seizes, so it just doesn't accept effluent anymore. So there's just a lot of history with our office with that area, so that's why the concern.
Yes, go ahead.
So just following on from that, so, I mean, there's no question, I think we all understand that there has been issues out there and that's got miserable soils, but what use will that your office or what use will be made of, if we don't waive that and they go out and do that work, what use will be made of that information?
Typically, we keep it, it's probably more knowledge for the buyer so they know where they are and what kind of system. Some of those systems that are required out there can be quite large. Many of the systems out there have dual mounds, so they alternate dose. So they take up, a significant amount of area. So it would be more of a planning issue. And, when they do the profile hole, it gives you a good idea what soils are there. So what type of system, for a commercial system, a mound or an ET bed, they get quite expensive. And I think that's just an expense that's likely to want to be known up front, I would imagine.
But it doesn't preclude having to do a specific one for any given lot that might, when this gets subdivided. It would not preclude having to do a soils test and a perk test for a particular lot.
No, you would still have to do it irregardless.
Yeah.
Is that what you're asking?
Okay.
Any further questions for staff? Any members of the audience like to speak on behalf of this item? Current recommendation for the first item is recommends approval of the portion of subdivision regulation variance 1904 to waive the improvements to Blackgap Road, and the second part is denial of the portion of subdivision regulations SV 1904 to waive percolation test and soil profile information. After our conversation, is there a recommendation or is there a motion to approve or deny or any adjustments?
I would move to approve.
I did not hear him.
He said he would move to approve.
Thank you.
Is there a second?
Mr. Chair,
Yes.
are you intending to approve item 1 and deny item 2?
No,
In the
I'm
variance?
sorry. I would like to approve both variances.
I'll second that motion.
Motion and seconded. Is there any further discussion?
Mr. Chair.
Yes, Rich.
My only thought is that I certainly appreciate staff's concern with the soil variability at the site and the problems that they've had in the past. It just seems to me that they could go poke a hole in the optimum place in that 25 acres and then have that be, the guidance for that 25 acres. And then it turns out that, 30 feet away or across the future road, we might have the same problems that they are currently having out there anyway. And so I think requiring them to, if we recommend approval of the variance to waive the percolation test will still be required for building permits, correct? Okay, then I don't see the reason to go poke the one hole at this point, essentially is where I'm at, so.
Any further questions, comments?
So just to be
Yes, go ahead,
clear,
Kathy.
so the motion is to waive both the road requirement, or the road improvements, as well as the 1904, which is the percolation tests and the soil profiles, to
Right.
waive both of those. That's
We
the
are going to
motion.
wait.
Was my intent, yeah.
All right.
Any further discussion? Seeing none, all in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. And then layout plat 1911, is there a recommendation for that? Because we have to address that separately.
Yes, yep, and staff is recommending approval of layout plat 1911 with 10 conditions.
Also move approval.
I'll second.
Motion and a second. I'm just doing a quick glance through. There's nothing that we just did that contradicts anything that's written in there. Is that correct?
That's correct.
All right, I just wanted to make sure. All right, motion and second. Any further discussion? All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries.
Thank you.
That takes us to item number, is that 13?
Yes. Again, there's a typo on this one. It says item 11 on one side and item 13 on the other. This is layout plat 1912. This is a request to combine 2 lots and then create lots 1, 2, and 3 of O'Sullivan subdivision. The applicant is Jim Peterson. He is here in the audience today if you do have any questions. The owner is John O'Sullivan and the surveyor is Britton Engineering. So as this property exists today, it is 2 separate tax parcels. The one tax parcel that you see labeled up here as 55846 is currently zoned general agriculture district. It's 10.47 acres and access is off of Burnt Fork Road. Currently contains a single-family residence and an equipment shop. It also does have an on-site wastewater treatment system on it. However, it does look like it is not functioning correctly. In 2018, it looks like it was discovered through an operating permit observation form that the tank was leaking, and the matter has not been corrected. It looks like it's since been turned over to the state's attorney's office for further action. And then there is another portion of this property, which up there is labeled as 44850. Those are 3 little tiny portions I'm not sure where those little tiny sections came from. They total 0.42 acres and they are currently vacant of any structures. So what they are proposing to do is combine those little tiny things into the larger lot and then create lots 1, 2, and 3 of O'Sullivan subdivision. Each one of these lots would be approximately 3 acres, which does not meet the minimum lot size requirement for a general agriculture district, so they will have to be rezoned appropriately or obtain lot size variances. Lot 1 would contain the existing structures. Lots 2 and 3 would be vacant. Access to all 3 of them would be off of Burnt Fork Road. Couple of comments that I do want to point out through the interdepartmental review process. The county environmental planning supervisor stated no action has been taken by the state's attorney's office regarding the deficient on-site wastewater treatment system on this property. Recommend that it be a condition of approval prior to any other plat application that the on-site wastewater treatment system is addressed. There is no special flood hazard area on the property. The county on-site wastewater specialist stated that the house located on the property attempted to obtain an operating permit. During the inspection, it was discovered that the tank leaked. Since then, the matter has been turned over to the state's attorney's office. This issue/repair needs to be completed and an operating permit obtained. Once the property is subdivided, any new septics on the newly created lots would need to follow all rules in Pennington County Zoning Ordinance Section 204J. And then Black Hills Electric Cooperative stated that they would request that all current power lines be surveyed on the new plat, and there are no other concerns with it, with the layout plat from their perspective. So the proposed plan, if approved, would combine the 2 existing tax IDs and then subdivide them into the 3 new lots. And like I said, the on-site wastewater treatment system, that was included as a condition of approval for this. Beyond that, staff does not find any significant issues, as those issues can be addressed before they move forward in the platting process. So staff is recommending approval of layout plat 1912 with 11 conditions.
Any questions for staff?
Mr. Chair.
Yes, Rich?
So there's no defined drainage. It looks like there's a significant drainage ditch or something that comes through the middle of all of these properties, but nothing's mapped. Is that correct?
Yeah, it doesn't look like any of it actually falls within what would be a floodplain. It looks like there definitely is a creek or something in there, but not in the floodplain.
So one of the recommendations is that all the natural drainage ways are maintained and not blocked. So they wouldn't be rerouting those or changing those.
They shouldn't, no.
Is there any additional review that's ever done with regards to the drainages if they're in an unmapped location?
If we get complaints and things along those lines about them, we will look at them again. If we start getting complaints downstream that they're getting more water, we'll look upstream and see if they have done any work in those drainages. Other than that, no.
Okay.
Unless a new floodplain map comes out from FEMA that puts it in the floodplain.
No further questions.
Any other questions for staff?
Mr. Chairman,
Yes, go
number
ahead.
11, the approval of this layout plat does not constitute approval of any further applications. What further applications?
We put that on all of our layout plats because getting approval of this doesn't mean that you'll necessarily get approval of a minor plat or a rezone or a lot size variance. It's just kind of your heads up that this is approval of this only. It doesn't necessarily mean everything else is gonna
I
go
see.
through.
Thank you.
Any further questions for staff? Any members of the audience want to speak on behalf of this item? Seeing none, current staff recommendation is approval of layout plat 1912 with the following 11 conditions. Is there a motion?
I would so move.
No second.
Motion and second. Any further discussion? Seeing none, all in favor signify by saying aye. Aye. All opposed, no. Motion carries. That takes us to item number 14.
All right, good morning again, PJ Conover, Director, Planning Department. Item 14 is conditional use permit 1910 to allow a multifamily dwelling in a suburban residential district. The applicants are Jeff and Jody Segru, and I believe they are in the audience here today if you have any questions. The property is located in the Silver City subdivision, and it is 0.36 acres. The existing property is zoned and currently zoned and future land use is suburban residential. It was platted back in 2004. Currently on the property, there's a 20 by 20 shop, plus a single-family residence, some attached decks, and it has a current operating permit. Basically, what the applicant is looking to do is to redo the unfinished basement downstairs to be able to have his mother live down there in an independent living unit. We don't have ADUs or accessory dwelling unit ordinances right now. The city is actually working on one, and we're keeping an eye on that. We also don't have multi-generational ordinances. So the closest that we have to be able to help the applicant get what they want is the multifamily request through the conditional use permit. Normally, multifamily dwellings are separate or are like new construction. This is actually an existing single-family residence where the basement is being refurbished into living quarters. A specific thing of note is that the kitchen that will be put into this multifamily dwelling, the applicant said is temporary. So when the multifamily dwelling is no longer needed, that kitchen will be removed. The conditional use permit, if approved, will end and will no longer be a multifamily dwelling. The septic is sized appropriately for the potential use of the additional bedroom from the proposed resident, so there's no concerns there as well. For the record, multifamily dwelling per section 103 of our ordinance is defined as a structure designed or used for residential occupancy by two or more families living independently of each other, which may include but not limited to condominiums, townhomes, apartments, and assisted living nursing homes. In that is the key word family. So then you got to go back and look in our ordinance what the definition of a family is. In section 103, that definition is an individual or a group of two or more persons related by blood, marriage, or adoption, and it goes on and so forth. So their request meets the definition of multifamily dwelling for our ordinance. It is also allowed in the suburban residential district if a conditional use permit is approved. This was routed through the interdepartmental review. The only item of note that came up, nothing negative, was from the county on-site wastewater specialist, is that the size of the current septic system was recently redone, and the proposed gallons per day is sufficient for the request. Also from the addressing coordinator in our office, they requested that the the unit proposed in the basement also receive its own individual unit number. And the county ordinance officer had just asked a question about what would happen with it once the use of as a multifamily dwelling is no longer needed, which we address as the landowner is intending to remove the kitchen, and then the conditional use permit would automatically end. With conditional use permits, as you've gone through many times, let me find this here. There are 5 factors that the planning commission may take into account as for your approval. The first one, staff's response is, it is difficult to determine what type of amount of effect a multifamily dwelling unit may have on the surrounding properties. Again, this applicant is looking to do the additional living quarters in an existing structure, so there's no new structures coming in. The applicant has also indicated the request is temporary. As of the staff report, the planning department has received at least 5 phone calls from neighboring property owners regarding the request. Only one chose to leave their name. And we've only received one list of comments in writing, which is included in your staff report. The calls that we have gotten were some against. Well, they all started out as against, but once they were told that it actually was a temporary use, I can tell you from the ones that I've spoke to, they were okay with this and had no further concerns. The second item of note, staff's response is the subject property is surrounded on 3 sides by property zone suburban residential district and on one side by Dugan Street in Silver City. And the applicant's request does not appear to have an effect on the normal and orderly development or improvements of the surrounding property as it is being done in an existing structure. The third item that the planning commission may consider, staff's response is that it appears that all necessary utilities and facilities are in place. The fourth item, staff's response is that there appears to be ample parking on the subject property to accommodate the necessary number of parking spaces, which is 4 for the 2 living quarters on the property. And the final item of consideration, staff's response is the proposed use for this conditional use permit by its very nature will have limited odor, fumes, dust, noise, and vibrations and intrusive lighting. And all existing lighting, exterior lighting should reflect downward so as not to cause a nuisance. And with that, staff would recommend approval of conditional use permit 1910 with 8 conditions.
Any questions for PJ?
Yes, Mr. Chairman.
Yes, go ahead.
PJ, I don't understand why there's a need for a conditional use permit. If somebody's mother-in-law moves in with them, I would think that would not be an issue, number one. Number two, I would think the presence of a kitchen in the lower level, there are many homes I've been in that have, sinks, refrigerators, cooking facilities on the lower levels. So how is this situation different from somebody's mother-in-law moving into a spare bedroom?
Some of the difference is that they're actually doing it and letting us know. There
I
are a
see.
lot of
I see.
the way it is. Staff goes off of a state's attorney's determination from years ago that if you have an oven or a range in that kitchen in a separate area of the house, it's considered separate living quarters.
I'm sorry, if you have what?
An oven or a range.
I see.
And so if you have that in a separate kitchen in that house, it's separate living quarters, and you can't have 2 living quarters in the same house without some other type of definition, hence this conditional use permit. If they weren't to put that oven downstairs, would be looking at a different issue, which we deal with that quite often. You have a lot of those wet bars and things like that.
Yes.
Some, when equalization goes out, they find a range in them, even though we're told they're not going to. But we do approve a lot of those, even in garages for people who want kind of they call them man caves or kind of hobby places. It is done. Our ordinance as of right now does not address that.
Yeah, our woman cages.
Yes. Tell you what we've done.
And that's fair.
Yeah.
Okay.
Yes, it is.
Okay, so she could have a hot plate and a microwave, and it wouldn't constitute the need for a conditional use permit.
Correct.
Okay, thank you.
I'm going to kind of add on to this one too, because I have a question about it. Is there a separation from the regular home and the basement so that it ends up being 2 living quarters where there's no, unless you go outside of the structure to go back inside of the structure, or can she get inside the structure like by walking upstairs?
I believe there are stairs inside.
Yeah, I'm kind of in the line with Sandy on this one. It's just if I had family come out and live with me, my wife and I do canning. I might be tattling on myself here. We've got 2 stoves in our house, and I didn't know this, but we put in a second stove so we could can. We'll have more space to can. I guess maybe that's why I was a little confused on that. If there was a separation where she couldn't get in there without going outside, maybe I can understand the multi-family dwelling aspect of it. But seeing that she could just walk up the stairs and go to inside the rest of the family's home, I don't know if I can see that same aspect either.
And staff does not necessarily disagree with you, but right now, this is the process that we have to follow. We are looking to change it. Again, it all comes from the direction given by the comp plan, which you've given already.
Right.
Mr. Chair,
And yes, go ahead, Gary.
I think Travis should leave his address with you at least.
We know where Travis is.
My question is relative on this, the letter from Mary Cordes Lucas. Most of the concerns she expressed are not a concern of mine, but she talked about the wells, possibly affect the wells. Any concern there at all?
It has not come up in any of the review. As the applicant did state to me during a conversation that the actual number of people, if this was approved, will still be less than what lived in there before.
Okay.
Any further questions for staff? Any members of the audience like to speak on behalf of this item?
No specific picture. Good morning. My name's Jeff Shagru. I'm the homeowner. My wife couldn't be here this morning. She's at work, but I would like to address some of your concerns, as has already been stated. And I'm going to read from my comments so I don't go off on a bunny trail and make this any longer than necessary. The reason for this CUP is to provide a living space for my mom, Joyce Shagru. This allows her to live in and enjoy the community that she's already a part of. The number one concern is we're not building an apartment complex, drilling any new wells, as was just addressed, nor increasing the traffic or noise in Silver City. I've actually personally spoken to Mary Cordes 2 days ago and addressed the concerns that she had in her letter. She and the Lucases and the Cundles that own a cabin just to the north of us are all now understand the purpose of our CUP and have expressed, they're actually expressing a deeper concern over how Silver City has evolved or changed from just little vacation cabins into larger residences as times change. That's their underlying concern. I don't think they have a major concern with my mom moving in with us. As to traffic dust and the impact to wells, when my 2 children were still in high school, and they're actually in the back row with us today, but they were consuming more water, and there was more laundry and more traffic, more noise when they were at home than there will be with my mom living with us. So I don't think that's a major concern. This is definitely not a vacation home rental and doesn't have high impact guests, multiple ATVs, and lots of noise and light pollution that may come with some of those vacationers that like to enjoy Silver City. My mom's been connected to Silver City since the 60s when we started camping there with friends. She's been a contributing member of the Silver City community for over 15 years. She's been a past board member of the Silver City Volunteer Fire Department. We're not doing this for the purpose of a future apartment in our house. The space was always planned to be finished as a guest bedroom, a rec room, and a bathroom, and that's actually in the original blueprints when we built our home. That's how we intended to utilize the basement. When my mom no longer wishes to live there, we intend to use it for that purpose by removing the stove and ending the CUP. I would like to briefly, and I'll only take 2 minutes, but I'd like to respectfully address the requirement for the CUP because I share some of your concerns that have already been raised. In reality, finishing our basement provides an independent living space for my mom in a multi-generational home. That's what my definition. Since the planning and zoning ordinance doesn't have a category defined for a multi-generational home, we're forced to request a CUP for a multifamily dwelling. This puts our single-family home in the same category as an apartment complex. Multi-generational homes aren't new. This is an accepted concept worldwide. And in fact, 1 in 6 American homes, or 1 in 6 Americans live in a multi-generational home. There's two important, this provides two important options for families. It allows aging parents to live in the same home as their adult children, and this provides them the opportunity to age in place affordably. Instead of moving into already full assisted living or nursing homes at a much greater expense. By allowing elderly parents to have a fully functional living space, including a full kitchen, they can live with independence and with dignity, rather than just being a guest at the table in their child's home. Governor Nome in March actually made comments along these same lines because of the problems we're having with nursing home beds and not enough space for assisted living in nursing homes. She said families are often the best caregivers for our parents and grandparents. And our parents and grandparents deserve good care and innovative ideas in how we can best deliver care for them. That we need to explore alternative, cost-effective options that can be developed for patients and their families, like expanding the continuum of care, developing community homes, and exploring other approaches that address the problems that are leading to nursing home closures. I like to think that we're being part of the solution instead of part of the problem here. By allowing her to have a fully functional home on our first floor of our house, and have her own kitchen, that also, I like to think, it prevents the problems that can best be summed up by saying having too many cooks in the kitchen. You've probably heard that saying. That's the reason that we want her to have a full kitchen, because she's still living independently. She still likes to have guests visit and be able to have a place that she can call hers. Secondly, and I'll be brief, multi-generational homes are also a solution that helps address the shortage of low-income housing for young adults that are still working on building their independence and can't quite afford to have a place of their own. I'll skip over that, but it reminds me of growing up on a ranch where you have an older generation that lives in one home. When the next generation on that farm or ranch grows up, they tend to move out of that house and build their own house right next door to it as they continue to work on the same farm and ranch, because you can't have too many cooks in the kitchen. Otherwise, the kids move off the ranch and you lose that young asset that is part of the solution to keep that ranch viable. Therefore, I would just say perhaps Pennington County could take action to be part of the solution that addresses the statewide shortage of beds in assisted living and nursing homes and low-income housing by creating an option that allows multi-generational homes, especially in the rural parts of our county. I hope the Planning and Zoning would consider our case as an excellent example of what a multi-generational home should look like, allowing elderly parents to age in place with dignity, maintain an acceptable degree of independence and privacy, and continue to contribute to their community. And it also allows adult children to live independently in a home owned by their parents while they build toward future complete independence. In summary, we've submitted our request for a CUP since a multi-generational home option currently does not exist. We accept all the planning and zoning's conditions and will fully implement them. We hope our example will provide planning and zoning with information that may help others have a multi-generational home in the future. And I just thank you and the folks at Planning and Zoning for working with us to find a workable solution that allows my mom to live independently and with dignity in our home. Do you have any questions?
Any questions for Jeff?
Mr. Chair.
All right, yes, go ahead, Sunny.
First of all, thank you for bringing this to our attention. I think everyone would agree with what you brought forward to us. I have a question for staff. We have on here that the full kitchen would be removed, but I believe you also said that it was the range that was the item. So can you clarify what?
It is, and I also heard Jeff say that the range was going to come out, but and maybe things have changed. In previous discussions, he had informed me that he told the contractor to make the cabinets and everything removable.
Yeah.
So if things have changed,
Well, the bottom line is we'll comply and remove the range. I don't know that I want to remove all the cabinetry, but I will comply with the CUP and remove the range so that it's no longer defined as a fully functional kitchen.
Well, that's why I'm asking, because of course I don't think it would be appropriate to force someone to remove the entire kitchen if it's just the range that is the item and that makes it multifamily, so.
right, we had made the condition based off of previous conversation. If they just want to remove the range, we can change the condition.
See, which condition number was that?
I'm looking
Four.
right now.
Any further questions, or do you,
So we can remove the term full kitchen and replace that with the range? Is that the only item?
Are you putting a stove, are you just,
It's a stove, yeah.
yeah. Stove unit? That work?
Okay, just so that the applicant doesn't feel like they have to tear out an entire kitchen.
Thank you.
Yep, that's fine.
any further questions? PJ, you said they brought this to your attention, so I've got a question about item number 6, where it says, that the applicant obtain a building permit with penalty fees for work that has already begun. So did they start work and then bring it to your attention? Is that why there's penalties and fees associated with this? I mean, that's just,
Well, they haven't applied for a building permit yet. This was a photo that was sent in by the applicant, and kudos to you for sending it in.
Yep.
And not hiding it. So when they apply for the building permit, because work has already begun, there'll have to be penalty fees assessed.
All the walls you're looking at are actually load-bearing walls that were already in place. The only thing I've actually done in that photo, but I have continued to work, and I'm being honest here, I've continued to work on the basic construction of the basement, but the wiring is new. So
the wiring is the only thing that's new?
at the point of that photo, yes, I've actually done a little bit more work since then. I haven't just stopped.
Okay.
So I am doing work without a permit at this moment because I didn't realize working inside my basement was going to require a permit. I'm the one that didn't realize I couldn't start. I knew that new construction, or if I added square footage, required a permit. I didn't realize working in my basement required a permit. So that's my fault, and I'll suffer the consequences.
Any further questions for staff or for Mr. Shagru?
Mr. Chairman,
Yes, Gary.
I would make a motion that we approve the conditional use permit and that we amend item 4 to remove full kitchen and instead say stove unit, and amend condition number 6 to put a semicolon after building permit and delete the rest of that sentence. Essentially what I'm doing is taking out the penalty fees and making the change that Sonny recommended.
I'll second that.
Motion and seconded. Any further discussion? Seeing none, all in favor signify by saying aye. Aye. All opposed, no. Motion carries. Thank you.
Much.
That takes us to item number 15.
Cassie Bolstead, Assistant Planning Director again. Item 15 is Major Plan Unit Development Amendment 1903. This is a request to amend an existing plan unit development to allow for additional lots to be developed on the subject properties. The applicant is Bill Freitag. The owner of these properties is Prairie Valley Development. As these properties exist today, these are located within the Prairie Fire subdivision, which is just south of Green Valley. It is currently 2 separate lots. Both are zoned planned unit development and located within the Prairie Fire planned unit development. Access could be off of Reseda Street or Mondo Street, both of which are located within the Winton Road District. And there is no special flood hazard area on either of these properties. To give you a little history of the Prairie Fire subdivision, it was originally approved for rezone from general agriculture to limited agriculture in 1994. And then in 2005, it was approved to be rezoned to a plan unit development with 12 conditions. The most recent time that the Prairie Fire plan unit development has been reviewed was in 2016. And the Board of Commissioners did approve the extension of PU 0603 with 10 conditions. The first condition of that plan unit development, I do want to point out, states that the plan unit development consists of no more than 75 residential lots, 1 well lot, and 1 detention lot with a minimum lot size of a half an acre. This request was routed through the interdepartmental review process. I do want to point out a couple of comments that came back. The County Highway Department stated that the development will increase the runoff, which flows to the north and crosses Southside Drive through an 18-inch culvert. The developer must either prove the increased flow will not cause overtopping of Southside Drive or make improvements to detain the runoff. Similar comments were provided to the City of Rapid City for their plat approval. Staff's comment is that these issues will be addressed by the City of Rapid City through the platting process. And then the City of Rapid City Community Development and Planning did state that they are currently reviewing a preliminary subdivision plan to subdivide this property into 89 residential lots. As part of the platting process, the proposed streets must be constructed to city street design standards or exceptions must be obtained. The city's future land use plan identifies the appropriate use of the property as rural residential, which typically requires 3 to 5 acre lots. However, with the connection to city sewer and water, additional densities are appropriate for this area. So as I stated, currently, condition number 1 of the PUD for Prairie Fire subdivision does restrict the size of the development to no more than 75 residential lots and a minimum half-acre lot size. There are currently 37 platted lots within the Prairie Fire subdivision, and within that PUD, 35 of those lots are developed with structures built on them. The applicant is proposing to add 89 residential lots in 2 phases, which looks like this up on your screen. It appears the lot sizes will range in size from 0.22 acres to 0.56 acres. And a document provided by KTM Design Solutions on April 8th, 2019, which you should have in your packets, does state a few things that are of significance. It states upon development, the proposed new lots will be served by Rapid City sewer and water utilities. The minimum lot size will be no less than 7,400 square feet. The minimum lot width will be no less than 50 feet. Minimum lot setbacks are proposed to be 20-foot front yard, 8-foot side yard, and 20-foot rear yard. And the proposed number of dwelling units will be no more than 109 single-family housing units. Staff does have a comment on that. Since there are already 35 established single-family houses within the plan unit development, and the applicant is proposing to add an additional 89 units, that would bring the total number of residential lots to 124 units. So staff wasn't sure if the 109 units stated by KTM was just for the proposed new phase, that it could be anywhere between the 89 that are proposed and 109, or if 109 was the total number of units proposed within the PUD. Because if the applicant is proposing that the newly developed area not exceed 109 units, then the plan unit development as a whole could contain upwards of 145 housing units. There is city sewer and water now available in this area. To staff's research, it was installed in 2017. So it does appear that a higher density may be suitable for this area now that there is city water and sewer connections available. So staff is recommending approval of major plan unit development amendment 1903 with 11 conditions.
Any questions for staff? Any members of the audience like to speak on behalf of this item?
Good morning. Michael Lewis. My wife and I are involved in the ownership of the land to the east, or to the east of Anderson Road. So if you're looking at this particular map, it's off to the right side of the property. Two conditions or two concerns that come up on that. One is, if you go back to that map for just a second for my first question, on both of these, the very south edge line that's kind of a wavy line there, that is actually south side irrigation ditch. And so one of the concerns is it mentions a 20-foot setback on the back of each property. And there is a 40-foot wide easement that exists for south side ditch. So that should accommodate that, but the documents don't recognize that there's an easement that exists there for the ditch. And that can't be encroached on and must be maintained for access for maintenance of the ditch. along that same lines, many of these rural developments, people who are along these ditches think that they can pump water out of them and irrigate their lawns and their gardens. And that's not within the rights of people along these ditches because they don't have any ownership in those ditches. The last thing on the ditch is you take weather like we got today, that south side ditch is flooded and it isn't even turned on for the season. And so there is some risk of overflow from these ditches to these properties, which would be in these south side lots would be on the downflow from that ditch. And so I don't know if that needs to be addressed, that the drainage that occurs outside of this area can easily flood these irrigation ditches and cause problems that the owners of the ditch and the water rights owners of the ditch can't necessarily predict and prevent. So the south side ditch there and the issues along those south is one concern. The second one is the highway department noted, as was noted, that their only concern was the 18-inch culvert that drains to the north toward Rapid Creek. I don't see anything in there that adding any words of 75 to 90 properties in there, what it does to the traffic on the areas. There are only two roads that have egress or ingress to this area, Anderson Road and or Reservoir Road that both connect in through Southside Drive. If you've ever driven Anderson Road, there's already a lot of traffic that comes and goes from the sewage treatment plant to the east. Trucks, semis, and it's also an agricultural area. And it's a very narrow road. And I don't see anything from the highway department, or at least I would recommend that they look at this to look at the amount of traffic that's going to be increased in this particular area. Just for this subdivision alone, you potentially are tripling the amount of traffic that's going to come and go from this development. Anderson Road, as it comes on the east side, is paved right to Mondo Drive, but then after Mondo Drive, it goes to gravel. But it's a two-lane, narrow road. And so I think my two concerns that I think need to be looked at in here that aren't addressed in any of the comments or conditions are the effect of the south side ditch and or traffic coming and going from this development.
Any questions for Michael?
Mr. Chair,
Hey, Rich.
do you have any ideas on how to accommodate the concerns about the ditch?
Right off the top of my head, I don't. We're just new to that ditch process, but they have an annual meeting that I've attended, and some of these issues about illegal access to the ditch and illegal pumping, either in or out of the ditch. This particular area we're not concerned about runoff coming into the ditch because it's north and downhill from the ditch. It would be any pumping out of it or any potential flooding overflows that would come out of it.
Okay.
The ditch property owners and water rights owners are required to maintain the ditch, but you can only do that within certain limitations of Mother Nature.
Mm-hmm.
Mr. Chairman?
Yes, go ahead.
Did you indicate that the easement is in fact recorded and of record?
Yes, and that goes back to the late 1800s when
Okay.
this ditch first came in. So it's there. The 20-foot setback that is mentioned would accommodate that, but
Sure.
I just don't know if that should be necessarily addressed as an additional easement that exists on part of these properties.
I see.
Go ahead, Ken.
Yeah, but, so the easement is 40 feet on either?
40 feet, 20 feet either side of the
Oh,
center of the
20
ditch.
feet on each side, okay, yeah.
Right.
All right. Is the floodplain issue of the ditch recorded on the FEMA maps?
It's not, and I didn't mention floodplain. It's not a floodplain.
But it
The
does
only
flood
kind-
occasionally, is that what you're?
Like when you've got significant water like we've got today, that ditch has only been turned on to about 10 or 15% for this year for irrigation purposes, but it is full and running over in spots. And so that can happen when you've got other runoff uphill outside of the ditch that's not properly maintained.
Have you ever seen it exceed the 20-foot easement?
Yes. As you get, not on this ditch, but on other ditches, there's a lot of that issue where people are encroaching on the ditches themselves, filling them in, trying to put driveways or crossings on them that block the ditches. So it's just, I don't see that necessarily here because you've got a road to the north. But it's just one of those things when you start doing planned development around irrigation ditches, people forget about the rights of the irrigation owners.
Any further questions? Thank you, Michael. Any other members of the audience have any input or would like to speak on behalf of this item? I don't see any. Any discussion on this item? I'm just gonna say, when I was looking at this, it almost looks like for the same development area, it's almost like they're adding 2.25 pieces of property in this whole development area. So 2 for 1, almost, a little bit over 2 for 1. And so they're really packing them in there. What is, Cassie, what is what was the total number again for that whole development area that they're allowed for the density purposes?
Well, KTM, they stated that the total number would not exceed more than 109. They're currently, through the city, proposing 89 extra residential units.
And how many already were there?
35.
35.
Well,
Go ahead.
okay. So how does if you add those up, what do you get? 140, 40, 100 and what?
4?
Yeah, so how does that square with the 109?
Yeah, that's 124.
And that was part of our question, is that the 109, is that potential for just this new development area, that the new area could potentially increase to 109 units? Or is it 109 total?
Well, what was the answer?
Staff did not get an answer.
But the recommendation number 1, it said it consists of no more than 145. So where does the 145 come from?
The 145 comes from the 109 within the new phases, and then the 37 lots that are already there.
Oh, 37's existing, not 35?
There's 37 platted lots, there's
Okay.
only 35 built
Gotcha.
on right now,
Okay.
because there is one
I see.
detention lot and one well lot out
I
there
see.
right now.
Okay, so if 109 is the proposed new lots, plus the 37, then you get the 145. So that really then allows for kind of the maximum number that could come in any of these.
Yes, yes. The
calculations.
145 is to prevent him from having to go through this process again if he does do 109 units within this development, because those are all things that'll be determined through the city of Rapid City in their plating process. It's our understanding that currently he's only proposing 89, but also in what KTM submitted, the minimum lot width would be no less than 50 feet, which it does have the potential to increase the density in there even more past the 89.
Go ahead.
Yeah, so regarding the concerns about the irrigation ditch that were brought up, this is an amendment to a planned unit development. Is it within our authority to add a condition? Just reminding the landowners that they must respect the easements and the water rights and so on of that ditch? I mean, is it something that can be done on a planned unit development amendment?
I would imagine it's a condition that could probably be added. I mean, we add conditions on plats that they have to maintain the drainage, the natural drainage and things along those lines. As far as the easement goes, we as county staff have not actually seen the plat that the city is reviewing for this. Based on the documents that I got from KTM and from Bill Freitag, it does not appear that the easement that the gentleman just spoke of that exists is on their preliminary plat. So that would be something that should be addressed to the city, and I'll make them aware of the comment that was made today. But staff has not seen the actual proposed preliminary plat from the city. But I would imagine, to answer your question, yes, I would say you probably could include a condition in there that states something along the lines of that the south side ditch be that the easements for the south side ditch be respected or.
Yeah. but
Not
I think
encroached on.
it strikes me that it's a little more than just the easement. It's actually the water rights rule so that people can't be pumping out of it and that sort of thing too.
And in terms of that, our office really doesn't have enforcement for the water rights. That would be the ditch. They'd have to enforce their water rights. Because we have that issue sometimes with like the Murphy ditch or the Hawthorne ditch. The only thing we can do essentially is call the ditch operators and let them know
Right.
the concerns or the complaints that we've got. If they come in and people are saying there's someone out there pulling water out of the south side ditch, our only avenue would be to call those ditch operators, because that's essentially their water right and they would have to enforce it.
So you're suggesting that there's really not, it's really wouldn't fit as a condition in the PUD?
Right, it wouldn't be something that we'd be able to enforce.
Yeah, okay.
Any further questions for staff?
One other question.
Yes, go ahead, Jim.
So my understanding of this discussion is there's no concern about, there's no floodway here, so there's no concern about a hazard to any of these properties in terms of water, damage or anything like that.
In terms of mapped floodplain, yes.
Okay.
But those ditches, I mean, he is correct. Those ditches do, I mean, they do come out of their banks, and so they are, they're not something that always stays within the ditch.
Right,
We've
okay.
seen the Murphy ditch
But
flood.
technically, there's been no definition of that as a floodway, so.
Right, yep. It's not defined by FEMA as a floodplain.
And the applicant is not here, I assume.
No, I don't see him.
Any further questions for staff? Any members of the audience would like to speak on behalf of this item? I see none. Staff recommends approval of the major plan unit development 1903 with the following 11 conditions.
Mr. Chair, I'll move to approve this planned unit PUD amendment, PU 19-03, with those conditions. But I'd like to add number 12, which just is, I'm not sure of the proper language, but just some recognition that the ditch is there and that they need to not encroach upon the defined easement of the ditch, or something to that effect.
It could state something like that the recorded easements for the south side ditch
Be acknowledged.
not be encroached on.
Be strictly, not be encroached upon or strictly, what's the word I'm looking for? Observed and not encroached upon.
Now, I think the presence of the easement needs clearly to be in the plat.
Yes, and I will provide those comments to the city, because I was reading through the city's comments that are included with your staff report that were comments from the city public works department for the plating process, and the south side ditch is not mentioned anywhere in here, so I'll point that out to them.
Okay, so that's my motion.
What's the wording of that so everyone knows, so that if someone wants to second it, they know what they're seconding?
That the recorded easements for the south side ditch be strictly, I don't know.
Be maintained?
Yeah, be maintained and not encroached upon.
Okay. Does that suit your
Yes, that's a good one.
I'll second for discussion.
motion and seconded? Further discussion?
Question on it. So Cassie, do you know on that easement that we're talking about, who originally grants those water rights? Does that come from the state then?
Yes. Yep.
Yeah, that falls under waters of the state.
Mr. Chair.
Yes.
Just some comments. It appears to me that regarding the traffic, I don't know if we can specifically address the amount of traffic other than to say that it looks like the roads will be built per City of Rapid City standards. And I don't know what the trigger point is for having, the improvements made on Anderson Road and Southside Drive and some of these other roads out there, but I'm assuming at some point the density out there will make that happen. It just may not happen immediately with this development. So,
Right. Any further discussion? Seeing none, all in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. That takes us to item number 16.
Good morning, Cody Sack, Environmental Planner. Item 16 is a construction permit review 1801. It's to review the installation of a 33-inch trunk sanitary sewer line from Southside Drive north along Reservoir Road. The applicant was RCS Construction, Inc. The approximate size of the disturbance, it was 7.5 acres. This was originally approved February of 2018 with 11 conditions. The work was completed last fall. It was reviewed again in January 14th. The Planning Commission continued the review of construction permit 1801 to the May 28th meeting to verify that final stabilization took place. Staff was out there on May 22nd to see if final stabilization has taken place, and it has not. It's a muddy mess out there right now, as a lot of things are. So with that, staff would recommend the planning director continue the review of construction permit 1801 to the August 26th planning commission meeting to allow time to verify that final stabilization has actually taken place.
Any questions for staff?
I just have one.
Yes, go ahead.
I'm just curious as to why this wasn't on the consent items. I mean, it just seems to me rather, there must be a reason, so.
Right now, we're still just testing out how to do the construction permits. We could possibly, and I don't know, I'd have to check with state's attorney, move some of the construction items over on the consent, or maybe even do their own separate consent.
I see, okay, the reason is because of the change in how these construction permits are really handled.
Correct.
So this is just really for our information.
This one is, yeah.
Yes.
Yeah,
And for public input.
correct.
Yeah, I understand.
More so,
Thank you.
yeah.
Thank you.
Any members of the audience have any input on this one? Okay, item number 17.
Do we move to approve this or not?
No, that's, we're just getting brief so that any members of the audience or any members of the public would like to speak on behalf of that, then we can give our input and then the director makes his decision.
Thank you.
Item 17 is construction permit review 1804. It's to review the construction of the parking area on a subject property. The applicant is Brooke Stromer. This was originally approved back in 2018. It's been heard several times over the past couple months in front of you guys. Last time was on May 13th, where it was continued until we could get in contact with the applicant. We finally got in contact with the applicant, and he does want to continue his construction permit. Last year, it was with the weather and some other things came up, he wasn't able to actually start construction. It was rainy, and then the ground out there froze early. So he would like to continue that or extend it. And so staff would recommend the planning director approve the extension of construction permit 1804 with 15 conditions, and one of those conditions being that number 13, that if the applicant does not start construction within 1 year from the approval of the extension of construction permit 1804, the permit will end and the applicant will have to reapply for the construction permit.
Any questions for staff?
Yes, sir, Mr. Chairman.
Yes, ma'am.
I thought a number of months ago, I believe it was PJ who addressed it, that the statement of understanding was no longer employed, that was no longer used, but yet I see it in here.
We decided to keep it with construction permits because as how we view construction permits is mainly as a contract, and we've even had issues just recently with another one that's coming up where they said that they didn't know that they were supposed to do something specific. So keeping that statement of understanding in there helps us say that you signed this document, you were aware of these conditions.
Well, sure, but I guess, I mean, if we're gonna use it in some cases, either use it in all or use it in none. Um, So, those are just, it's my personal comment that, you know, when PJ discussed it, he indicated that people sign it, but they don't remember what they signed. But I think having a signature in a document certainly gives it more credibility than otherwise. Just a thought.
No, and I appreciate your thought. I don't want to go into a long history of statements of understanding, but
I know.
even though when we get them signed, they're basically ignored by the people that sign them. They've even said, even though they are notarized, that that's not their signature.
I see.
But we felt that at least we should retain them with the construction permits, but we hear you as far as do it for all or do it for none.
Sure.
So I talk about it with staff and see if it is something that we just want to keep it. It does take a lot of staff time to hunt down signatures, and sometimes we never even get them for a year. But we felt for construction permits, we would devote that extra effort to get
Sure.
statements of understanding done. But for something like a multifamily dwelling, like you've heard today, not as necessary.
Thank you.
But thank you for your comment, though.
Thank you, PJ. Any further questions for staff? Any members of the audience like to speak on behalf of this item? All right, item number 18.
Item number 18 is construction permit review 1902. It's to review the construction of a graveled access road to and onto the subject property to include minimal tree removal, grading, gravel, seeding, and culverts, and to add a common utility trench for power and communications. The applicant is SiteWorks. This was approved back in February, on February 25th, 2019, with 14 conditions. And then it was also reviewed at the March 11th when the applicant contacted us and said that they would like to add the utility trench to be a part of the permit, so they didn't have to come back in and apply for another construction permit later. We just amended the permit. On May 16th, staff had a conversation with the owner of the actual subject property, who was unaware that there was a stop work order in place on the property, and he indicated that work was actually still being done. And he also stated that there was no erosion or sediment control measures implemented on the property, which would be number 1 and 2 of the conditions that were placed. Condition 2 states that all erosion control measures submitted with the construction permit application be implemented prior to the stop work order being lifted. And number 1 was that they were implemented immediately and maintained until the site was revegetated. Staff contacted site work specialists by email asking if those erosion and sediment controls had been implemented on the property. They stated that they were unaware that a stop work order was in place or a time limit was placed for the erosion and sediment controls to be implemented. But like I said, condition 1 and condition 2 stated that they needed to be immediately and that they need to be placed before the stop work order was lifted. They also indicated in an inspection report that was dated March 1st that compost filter socks were to be installed when work continued. Works continued and those aren't in. So they had plans to put those in. I don't know what their plans are now, apparently. It also said see attached. That paper did not get put in the packet. So staff would recommend that the planning director continue the review of construction permit 1902 with the following 12 conditions until such time that erosion and sediment controls are implemented on the property.
Any questions for staff?
Mr. Chair.
Yes, go ahead, Rich.
So contact has been made with the applicant and they're aware that they need to do this and they have indicated they will or will not do this?
They indicated that they wanted to get together and do a meeting. Unfortunately, I was out of the office much of last week and I wasn't able to be a part of that meeting. But on multiple occasions in person, when they dropped off those inspection reports, we told them that those erosion sediment controls need to be implemented, and that because on there, what they did was on their application, they put as needed. It's needed. I mean, as you can tell with the rain and everything, it's needed. Staff even gave them the option. We mainly cared about the down slopes and the drainage, to protect those, and they were made aware of that. And every time she or the person from Site Works dropped off the inspection reports, I always asked if they'd been implemented or if they were working, and it was always, no, we're going to start soon. We're going to do this soon. And according to the owner, they've been working for quite a while.
So when there's a stop work order and they're working, is there a phone call that's made that tells them to stop? Or how does trying to understand the process forward here so we don't get ourselves into another NIBL scenario?
So I can tell you that they did know about the stop work order because I spoke with the vice president back in February, the day that the ordinance officer was issuing it, and told them that it was going to be issued.
Okay.
In our ordinance, and this is something that we're correcting immediately, is in the stop work order section, it refers to the wrong section for what the penalties would be.
Okay.
So right now, no, there really isn't any enforcement other than taking their word for it.
But they're all aware of it.
Very aware.
Okay.
Any further questions for staff? Any members of the audience like to speak on behalf of this item? All right, that takes us to item number 19.
Item 19 is construction permit 1906. It's to excavate for a pond and to use the dirt to level an area for a future barn. The applicants are Pat and Emily Rowe. The applicants submitted a construction permit to excavate an area for a pond. There's a lot of drainage on their property. And he just wanted to, over here's the pond, you can kind of see right, and here's the outlet for it, and here's the pond. The work's already been, as you can see, started and completed. We got a complaint about this, and by the time staff got out there to verify the complaint, the work had been done. They did contact the state department and asked if they needed a construction permit with them, and they didn't need the general permit. So they didn't even think about asking us because they thought if the state didn't require one, we wouldn't require one. The area of disturbance is roughly 0.65 acres. There is no special flood hazard area on the property. One main concern that came up in the routing was from the U.S. Forest Service. It appears that part of the portion of their road accesses partially into the National Forest land. This is what he would have been received. These lines aren't survey quality. So if it does turn out that the road does go on to National Forest Service land, the applicant will have to work with National Forest to get the approval to use that road. But that road is already existing and not part of the construction permit. It was just the area for the pond. Sorry, I didn't put the site plan in here. The pond area is is right in here, and then the barn leveling, they put some dirt from that pond up here to level for a barn, which they did apply for a building permit for. So staff would be recommending the planning director approve construction permit 1906 with 11 conditions.
Any questions for staff? Any members of the audience like to speak on behalf of this item? All right, I believe that takes us to item number 20.
Item number 20 is construction permit 1907 to add fill to and grade a low spot on the subject property. The applicant is Fatter Boys LLC. The area of disturbance for this construction permit is roughly half an acre. Here's the site plan for it. This is the area that the work's already begun. As you can see here, he has installed some silt fence and some wattles to protect the drainage down here. This area that you see circled here, it's hard to read, but that's where most of the fill area is coming in. The rest of it's mainly kind of grading to level out for, I believe, future tent spots. One concern that was stated was that the work is in the 100-year floodplain. It does not appear that the work did go into the actual floodway, just stayed in this blue area. And the applicant is working with us to get a floodplain development permit. He did submit a floodplain development at the same time that the construction permit was submitted. However, there was some work that was done after that permit was submitted, so he's going to have to resubmit that floodplain development permit. But he is working with us to get that done. And so staff did make it a condition that the planning director not approve this permit until an approved floodplain development permit is approved. It's one of the conditions. It's number 2. And then staff would recommend the planning director approve construction permit 1907 with 13 conditions.
Any questions for staff? Any members of the audience like to speak on behalf of this item? All right, thank you very much. That's going to end the construction permit agenda. I would entertain a motion for a 5-minute recess if y'all would like to before we get started.
So moved.
Second.
Motion second. All in favor signify by saying aye.
Aye.
Aye. All opposed, no. Motion carries. We'll reconvene at 10:41. All right, since we're all back, I would entertain a motion to reconvene.
So moved.
Second.
Motion and second. All in favor signify by saying aye. Aye. All opposed, no. Motion carries. Takes us to item number 21.
If I may, Mr. Chair,
Say again?
if I may.
Yes, go ahead.
Okay. So the last meeting, we got through even Chapter 11, but I don't believe you were here, Sandy, last.
And I left in the middle.
Yeah, and some of the concern was of the timeline for the goals in Chapter 11. So I thought it would be okay, suggested in the memo that we bring Chapter 11 back up. Also, there is a citizen in the audience that has a comment on Chapter 11. And if you'd like to hear her first, it's up to you.
That sounds good.
Okay.
Thank you. My name is Joyce Chigru, and my comments are related to the new comp plan. But there's nothing like having a personal issue that sharpens your focus, okay? So for those of you who don't know me, many of you do, I've been here many, many times, I did attend all of the public meetings for public input that the contractor held in the county for development of the new comp plan. So I'm somewhat familiar with it. So as we're going through this process, I went back and reviewed the new comp plan to see what it said about multi-generational housing. I knew we had a section in there for affordable housing, but when I was attending those public meetings, I wasn't focused on multi-generational. And of course, this is very personal to me, and I can give you some reasons why. One is that finances are a part of this. My age is a part of it. And I had a house, a very nice house by Johnson Siding, and it got to the point where I couldn't do the outside work. I had to hire someone to do it. It had stairs. I calculated my budget, and my expenses for housing were going to exceed what I budgeted during 2018. So I knew that was the year that I had to sell. So I did, and I was very fortunate. I just took my time getting ready to sell. I put it on the market with Tom Rao, who's a good realtor, in September. He told me it would take 3 to 6 months. My house was valued at $359,500. Half acre, nice house, love that house. And he said it would take 3 to 6 months to sell, and then we'd have 60 days before closing. It sold in 3 days. I got asking price, and I had 40 days. So I had to look for a place to live. I thought I had time. And so I'm now renting in Silver City, and that's part of my personal issue. One of the things, people my age, I'm very independent. travel, drive. I'm very independent. But I'm not young, okay? And so safety is an issue. So I'm renting a cabin house in Silver City at the end of the line, electricity and telephone. Last week, we had 2 feet of very heavy snow out there. Our electricity was off for 3 days. The ones like my son and his family and others, Todd and Judy Tobin were here, Todd and Judy don't have a generator, but most of them have one of these big automatic generators. You don't even know the lights have gone off. Mine is a family vacation home. It did not have a generator. So my lights went off, okay? Then my telephone went off, and I still do not have telephone. Cells don't work where I live, so I have to depend on a landline. I still do not have one. It's more than a week ago. And, you know, I'm on a well with a septic before very long. You've depleted the pressure in your pressure tank for water, and you don't have water. So I went to Jeff and Jody's. But as independent as I am, it was scary for me because the snow was very deep. And so anyway, so there's reasons I needed to do this. I looked at housing in Rapid City. My income is right in the middle of what people who are earning wages in this state make. So I'm not impoverished. My income is okay. And I've got good backup. But I went to look at places like shared wall or apartments, and they are expensive. And what I would like to have done, I decided I couldn't afford because it would take all of my money for fun. So I thought, okay, what am I going to do? So I ended up, Jeff and Jody offered this part of their basement. And I hesitated. Now, Jeff had done a lot of research in the literature for what he presented this morning, but it was actually right on. The apartment, there's a door that goes out into the common area upstairs. To get to the garage, I'll go through their house rather than walking outside. But I do have an outside entrance that's ramped. And we're designing it so that when I'm in a walker, I can still be there. Very careful about arthritis. The pulls, the shower is walk-in, no slip. It's an ideal situation for me. So I look back at the comp plan, and we don't talk about multi-generational in the comp plan. We talk about affordable housing, and that actually, you know, I could find a place to live in Rapid City, but what I wanted was expensive, and I wanted some money left over for fun. So the comp plan relates to multi-family dwellings and affordable housing, but it's not designed to be a rental place. Okay, it's designed for me, the mom, the grandma. So there's a difference between the two. And the point I wanted to make was with the comp plan, as you're going through and approving it, then it will get to the words that were used. I had implementation plan, but the words used in the plan is there will be implementation actions. And when you get to, or the staff get to that point, I'd recommend they think about multi-generational, and I know they will, but think about multi-generational. We've had a lot of fun with this, actually. The stove thing, I thought, okay, I spent a month one time with just a microwave, and some people can do that, but that's not me. A microwave is not adequate. I need to make a pot of soup or fry an egg, and I need to bake some cookies. So I need a cooktop, and I need an oven. And I have a beautiful range sitting there to install. But I thought, okay, if I can just have a microwave, we'll redesign the kitchen, and I will have my range. Instead of 4 feet from the counter, I will walk 20 feet and pretend I have a great big kitchen, and we'll put the range out in their common area. Now, that's the way people think when they're really in a bind and it lacks common sense. So I think maybe as we go through the action plan, or you all do, go through the action plan, think about those things and the way people get around them, and what can we do so that people don't have to do that? Now, we had a builder tell us, go ahead and just do it. Okay, that's not us. So we came before you. And so, but you can learn from people like us because we went through all those things like, okay, I'll just pretend I have a big kitchen and I'll walk 20 feet to that beautiful range. So my point is, as you develop action plans for this, think like we do, and then maybe we can have something that makes more sense. Do you have any questions?
Any questions for Joyce?
Mr. Chairman?
Yes, go ahead.
Yeah, ma'am, do you just recommend we include it in the implementation program? The language that we
That would
consider?
be good because as you do, Jeff did a lot of research on this, and as you do the research and on the state, we need to advocate for more multifamily dwellings. And that's sort of strange for me to say because I came from a development where we're single family dwellings and adamant about that. But that probably is not a good thought process for the future. We need more multifamily and multi-generational both.
Yeah, and my question is simply,
Yeah, put it in there.
do
Yeah.
you, is your recommendation to add to chapter 11 an item that would indicate the reviewing of
If
multi-generational?
that fits within there, yes.
Okay, thank you.
Okay,
Thank you.
thank you.
Any other questions for Joyce?
Thank you.
Thank you very much, Joyce.
Enjoy your new place.
Yes.
I will.
But on that point, just, I think I was looking back and really, we probably ought to include something in, this is on actual page 3-10. It's goal LUH2. The title of it, the county has a diverse housing stock that meets the needs of all county residents. And then it lists 6 goals under that. Really, it seems like we probably ought to go back and,
Which chapter is that in?
it's in chapter 3.
Thank you.
Where at the beginning?
And which one is it? 3-10 what?
It's LUH-2.
Right?
Strikes me that maybe one of those could be amended to mention multi-generational.
Mr. Chair,
Yes, go ahead.
when we talk about this multifamily and multi-generational, I think they're completely unrelated. I mean, when we look at our definitions that we were in item 14 for SAGRU, we see here that the family is defined as by blood, marriage, adoption, et cetera, stuff that I think we all agree is family. But on that issue, they were treated as multifamily, but they're not multifamily. So I find this really confusing. And we're talking about multifamily still, but this is multifamily where you have like 2 separate dwellings within one lot. Multi-generational isn't that.
Right.
Why do we need to have multi-generational if it's not multifamily? Does that make sense? I hope.
It does, because multifamily is apartments. Well, at least I see multifamily dwelling units as like apartments or what are the ones with just a home and it's
Duplex?
a duplex,
Townhouse.
duplex or quadplexes. That's what I see. Is that where you're going at with?
Yeah, I'm saying the multi-generational because it is family. It's not multifamily. So, but we seem to be conflating it, aren't we? I mean
Mr. Chair, the bigger concern from my standpoint is what happens when that family sells that house and the next person that buys it wants to make it a duplex and it's not on the books as a duplex, and the problems and everything that come along with that I'm sure PJ could talk about for hours and hours. So I think the important thing is the physical changes that are happening to the structure that make its functionality more than it currently is. And so whether they're the same family members in the basement or whether they're people they're just renting it to in the basement, I think that the requirements for that structure are really the thing that the county is concerned with, not necessarily whether it's blood relation or not. Just my opinion.
No, that's fair. I would ask this question, and maybe PJ can better answer it. Some people who have basements and whatnot, we've considered for many years making a separate kitchen for my wife to do canning. How would that fall in? I mean, you're talking about putting in a whole new range down in the basement because it's cooler. So then how would situations like that affect? Because really, you've got to be careful with that, because if we're calling that multifamily, but we're not even adding in another person in there, we're just putting a kitchen in another area of the home.
It'd be an additional living space, which is not allowed. Don't forget, staff agrees with you that there needs to be a change when we tried to find the best fit for the SAGRUs that we could with what's existing right now.
Well, then let's put in something in here that indicates that we review multi-generational housing.
And we can. That is actually under ADUs, I'm sorry, accessory dwelling units, which is what's listed in that chapter 11 under that goal. Accessory dwelling units can be an accessory structure, which is how the city is defining it with very specific criteria, kind of like what we do with caretakers residents. And that's one path we're looking to follow after they implement it, and we'll see how it goes. But also, it could also be, as far as the definition of an additional living space in the same building, kind of like what the SAGRUs have right now. So there's a lot of different terms for it. We know that it is a pattern or we're seeing a lot more of it, especially as the generation is aging and they're coming in. We see a lot more need of it. And what we have right now for multifamily caretakers residents, that's not cutting it. And so we've been keeping an eye out on what other possibilities there are and encouraging the change through the comp plan and the zoning ordinance once the comp plan's done.
Well, as long as this addresses the fact, obviously we can't solve it today, okay? But it appears as if it ought to be at least incorporated into this comprehensive plan, so
Sure.
somebody else can solve the problem
Yep.
in the future.
But, Mr. Chair?
Yes, go ahead.
So PJ, so what, did I hear you correctly that on LUH 2.2, which addresses this county shall encourage the development of accessory dwelling units, you're under the understanding that the term accessory dwelling units, it includes situations like the SAGRUs adding the multi-generational living unit. Do I understand that right? So you're suggesting we don't need to specifically call anything else out because this covers it?
It depends on how ADUs are going to be defined in the county. Right now, there's accessory dwelling units, ADUs do not exist as a structure or a living space in the county. The city, again, they've developed an ordinance and had public meetings, and they're going to see how that goes. They've defined it separately as it is a separate structure or a separate living space. I mean, it all depends on how you want to define it. So as we move forward, to answer your question, it would really depend on how we define that in the future. Now, the Planning Commission can kind of toy with a definition right now, or at least give staff some direction of what you want the definition to have added or to include, but I think I got a pretty good idea of where you guys are on it because we're on the same page.
Yeah, I guess I mean, it sounds to me like there's a fair amount of several bridges to cross before the actual ordinances get laid out. So, what harm would it do to provide a little bit more definition in this 2.2? We could either say development of accessory dwelling units defined as either unit within a home or a separate structure, or just to provide a little bit more to this.
Or you could even say, for example.
For example,
and then
I think that's
list specifically.
Yes, and
the
I
different
like
things.
those for examples. Yes.
And then there's also the occurrence of if somebody has a child with a disability or a child is taking care of a parent with a disability or relative, that's not necessarily multi-generational as being defined, but it's a little bit different. So we have to make sure it's as inclusive to all that. It's not always as black and white as it comes across in the beginning.
I agree with that. I think.
Mr. Chair,
Yes, go ahead, Sonny.
I don't know how much family really makes the difference in any of this. Is it not that the dwellings are separate? Obviously, if it's a separate structure, that's easy. But if it's just a basement and they're connected and there's not two addresses, it's just one dwelling. So are we talking about families? Are we talking about dwellings? I think we're talking about dwellings. Now, whether it's a kitchen or an extra bathroom or whatever, I don't see how we can use a kitchen as the defining term of a different dwelling.
It's a stove.
Correct. That was developed back probably 5 or 6 years ago by Patrick Grody from the state's attorney's office. And that was a defining factor. Since then, the increase has been for a use of, having multi-generations in a family. It gets away from having multiple structures on the same property. And the definitions of family and the multifamily and stuff, these are old definitions, which we know are not cutting it anymore, which is why we pursued having this overall complete change done. So we feel your pain, and we appreciate all your input because it's very valuable to this process.
So it seems to me that the definition would be three things. One, it would have its own entrance. It would be separate from the main dwelling if it's in one building. So a lock on both sides of a door that separates the two halves, and being able to have its own address. And then we have a different dwelling. I don't know if family really makes any difference. A family could rent a part of their house to their children or their other family. I mean, but that's what we're talking about, right? It's the ability to say we got two dwellings, one could be rented.
Right.
Then kind of like what Commissioner Marsh was saying is there's always the possibility that we say it can't be rented, but it's going to be rented. And also then what zoning districts would this type of use be allowed in? Is it going to be allowed in all of them or only select few? Or is it going to be determined by acreage size, kind of like vacation home rentals are for? So I like where you're going with it. I really do. And I think it's something that warrants more discussion as we get in, when we get into the zoning ordinance after the comp plan is done.
You make a good point, depending on which zoning it would fit in, would it be allowed in certain ones and not others? I would think if you're going to look at multi-generation, you'd have to at least consider all of them.
I would agree.
I mean, because,
Be fair.
it's somebody's home, and grandma's coming to live with us because she can't live on her own, and we can't afford to put her in a home. It would have to transcend all of them that allow living dwellings. So, I don't know. Yeah, that's a good point. I think, Sonny, I think that's, I agree with you. Why is a stove the contributing factor that dictates that?
Because they can't come up with anything else. Bathrooms are too common.
Bathrooms are common, that's
And
correct.
certainly bedrooms and closets are too common. So you've got to have something that would be sort of singular to someone who was renting from you and not really living with you. And I suppose the idea of having your own kitchen complete with a stove, I think it's a weak feature, quite frankly, but
I think
it's the only thing that
Just for clarification, you could have an entire kitchen minus the stove and be okay.
right.
Right, yeah.
Right.
That's what I mean.
But I think the defining factor should be more of, do you have access to that other home very easily? I mean, even when Sonny was talking about it, he said, well, you have a locked wall, a locked door. Well, even a locked door could be, quite frankly, that could be manipulated. But you'd have to have it where there was no access from one dwelling to another dwelling without departing the dwelling. And I know this could even get goofy, but without going outside or something. You know what I mean? Yeah, it gets kind of confusing. I think that would be closest to defining what considers another dwelling versus for another living dwelling, rather than you just adding on, or maybe not even adding on, but expanding the use in your current
Like
home.
a wall.
Oh, you sheetrock
A
the
wall,
door.
yeah. I mean, that's probably the easiest. You can sheetrock a wall through there. Granted, some people don't want to knock out a door frame to seal up a door frame with a wall. They'd rather just bar it one way or the other. But even that looks kind of goofy. And then again, are they even doing that?
I also think that family and generational, those terms are kind of getting in the way of the point that
Right.
we're talking about dwellings.
Right.
Because, like I said, you could rent a room to somebody who's in your family. It's two dwellings. It's not, so it's different still.
Right, by technicality, yeah.
Where you're changing the tax structure of the
Yeah, and
buildings too, and
that's the key thing,
Yeah.
I think.
Wow. Okay. All right. Anything further on that as we move forward, or are there any questions that were not addressed, PJ, since I wasn't here for that last part?
Yeah, so the other directive for the staff was to go through chapter 11 and see if there was anything as far as timeline that we would change. Having looked at the specific short-term, mid-term, long-term goals, staff really doesn't see anything that they would change. Yes, I absolutely agree with Commissioner Rundy that it seems like there's a lot of short-term goals, but I believe that they're necessary
Sure.
for the change that we want.
Yeah, and my comment was merely, in as much as they included the category of long-term goals. There were none listed. And so it just seemed odd to me.
But, I'll tell you what, because I was thinking, and I did kind of another overview of this, in preparation, and, what's really striking about chapter 11 in my second look at it isn't really that there's so many short-term and very few longer term. It's how few goals from this big plan are really listed in this
Sure.
implementation.
I would agree.
That's
Yeah.
really the striking part.
I must be missing something here.
And so what did, what's the plan, I guess, or what's the staff's idea on what to do with all these goals that aren't listed at all in the implementation?
Yeah.
Well, we would use the current chapter 11 as a guide, but definitely referred back to the contents of the chapters. I know, I would think, and I can't verify this, that some of these goals in chapter 11 contain multiple ones from the other chapters. I don't know that for sure. I'm just
Well,
assuming.
I think they use the words, these words are exactly what, like, for example, LUH2, and there's several from LUH2. They have extracted the bullets from LUH2 to do this. And so, and I think, well, now why were these picked out, I guess?
We take the document as an overall direction, not necessarily just chapter 11. That's a check the boxes type of thing. But the overall direction is going to come from the entire document.
Well, then here's my comment, really, and that may be a fine approach. I'm not really weighing in on that. But I think it needs to address how these were selected, or how these are going to be used compared to all the goals that aren't mentioned. I mean, I just think there needs to be a
Why
little.
these and not others?
Yeah,
kind of a thing?
exactly. And
I'm also struck at how many of them relate to Ellsworth Air Force Base.
well, I know that's exactly. I know it.
I know it's important, but I mean, there must be a third of them or thereabouts that
Yeah.
in things like noise suppression and stuff.
ACUS area.
I know that's important, but my God.
I'm going to point out, when you talked about how much of it affects Ellsworth Air Force Base LUH4, unless I'm missing it, I don't even see it in the listing as a goal. And if you look back at LUH4, land uses in Pennington County are compatible with Ellsworth Air Force Base Rapid City Regional Airport operations. So they're not even looking at that as a goal to make sure that we keep the land use appropriate.
These seem more specific,
Yeah, I know.
commands from these
Commands.
Yeah, well, who put together the 30-item list, PJ? Was that from your recommendation or from the people that created this? They just arbitrarily went through, or?
So there's a little bit from us. A lot of it is from Matrix from the public meetings. That's how the whole document came about. How they extracted the specific ones and put them in here, I didn't ask.
I see.
I didn't ask
Okay.
that part of it.
Just-
But I know some of the Ellsworth stuff is addressed because they mentioned the zoning ordinance.
Right.
And that's where we talk about the compatibility.
And just remind the planning commission roughly how many public individuals were at these meetings. I know there were several meetings. I just want to make sure that we're all aware that those meetings were not highly attended, if I remember correctly.
No, they were not. No, I'd say less than 100 total over, what, a year and a half?
Over a year and a half. And I know I went to a meeting and there was like
$100,000
3 of
spent.
us there.
Sure.
So,
There's a lot of cry for change,
I understand.
but actually showing up was very small.
I understand.
so there's probably a lot of holes because there was a very small sampling of
Sure.
the county that was involved
Sure.
in developing this. So I'm going to assume Matrix had to plug holes where they felt that was appropriate to.
Yeah, originally there was only 9 public meetings that were scheduled. And at the time, that Board of Commissioners thought that wasn't enough and then added an extra, was it about $30-some thousand to add 6 more public meetings.
6 more meetings.
Sure.
I mean, there were meetings that we had in Hill City, nobody showed up.
Yeah, I understand.
Oh,
It was really in the very beginning when most of the people started showing up because they wanted to know kind of what was going. So those earlier meetings that set the the mission statement and the direction. You know, we got a lot of input with that, but as it got in later about the maps and the rezoning and that kind of stuff, that's when participation started dwindling.
Well, no two people will agree. I mean, you can have 1,000 meetings
Yep.
with two people at each meeting,
Yep.
and you will not have a concurrence of the entire document.
It just seems to me there needs to be some more kind of an overarching view of how this will be implemented. And there's nothing wrong with picking out these 30 items or whatever the list is. There's not, but it's like it's missing something because, for example, the chapter on economic development, it's chapter 4, and it's ED, economic development thing. They're not listed at all. So why does economic development didn't make the list, as an example? And there's several others like that. And because I think that some of these should be, I mean, and maybe it's because they're not, it doesn't require zoning changes, or it doesn't require, you know, some specific things that you have total control over. And if that's the case, then maybe that needs to be spelled out. But there just needs to be some kind of larger view, I'd say.
Yeah.
Will you Mr. Chairman?
Yes,
Do you
go ahead.
recommend like an item 31 that indicates something to the effect that we should, well, oh, it looks like 35. Oh,
Item 35.
Okay,
Yeah.
35.
yeah, I missed it on the other page.
And I quoted you, so I was. But anyway.
But do you think we should add number 35 that indicates all items outlined in the comprehensive plan should be addressed at some point in time? I mean, that's a blanket statement, but.
Right, but I think that may be something worthwhile adding, but it strikes me there needs to be something at the beginning so that we understand what these 35 items really is
Sure.
intentional, and what happens to all those that aren't on that list, and
Is there a
what's
reason?
the view?
Is there a way to find out from Matrix why they chose those? I mean, can you
Absolutely.
reach out to them and get back to us so that we can have that information of why just these? I mean, because it looks like there's a lot of others, but why is it just, what are we missing?
Yeah, I actually wrote that down from what Commissioner Johnson was saying, is why some and not others. And I'll ask Rick.
Because that might open our eyes. They might say one thing, we're like, oh.
Sure.
Well, and some of these don't speak to planning, land use planning much. I mean, the county should provide services and facilities to support the needs of agricultural uses. Well, I mean, other than an ordinance that provides for limited and general ag, I mean, I don't know where that, you know,
Which
that
one? What number?
particular is not included. Well, was it just meant to emphasize the importance of certain economic and social activities? I think we do need to know how they came up with these, because I kept thinking, there must be pages in my book that have migrated somewhere else.
It's like, where, I missed that.
And actually, PJ, I think I misspoke a little bit when I said these bullets, these statements 1 through 35 are word for word of the bullets. I don't think that's always the case. I think in some cases it is, but not. Like, for example, I know one that I looked at, and action item 3, that is kind of an amalgam of several of the LUH ones. That's not a bullet itself. So there are instances where these aren't exactly taken from those bullets,
Okay.
but then some of them are. So it just depends. And
All right. Any other pressing issues on chapter 11?
Do you need a motion of some sort, or?
Correct me if I'm wrong, there wasn't a motion last meeting to accept the current chapter 11, right? I could be wrong. I just want to make sure.
I guess I'm thinking it's a bit premature to accept this when
Correct.
we're.
Well, not
You're not
accept it,
there
but,
yet, no.
well, not
That-
accepting it,
You're
but,
ways away from that one.
yeah, not accepting it in that aspect, but what is currently, what we've asked to be clarified, what we've what we need more information on, accepting all of that to move past that so we can get to the next aspect of this. Because there's still going to be, once we get all this done and we go through all the maps, that's what I was pulling out, because we do have to at least view the maps, because y'all can correct me if I'm wrong, we haven't really touched on any of the maps in here. We'll have to go through those, and then all of the feedback that we voted on here to say, let's get this in there, let's get that in there, let's fix this, let's adjust this. Then it goes to Matrix, they correct it all, and then it needs to come back to us for another review to make sure it's all in line with what we've asked for.
Correct, and after they create an edited document, we're gonna give some more time for public review, advertise again in the paper that the document is out there.
Goodness, this
And then
could
bring it
take
back.
years.
Well, it's a 20-year document, so we wanna make sure we get it
Yeah,
right.
they want to get as much, but hopefully, seeing something produced, maybe that'll drive some more input for future meetings so that we
Sure.
have better clarification.
Interesting.
Okay, so I'll move that we approve the direction given to staff to provide additional information and background on Chapter 11. How's that?
I'll second that.
Motion and seconded. Any further discussion? Any concerns?
Mr. Chair.
Yes,
So
Rich.
the question is how are the goals in Chapter 11 selected
Yes.
That's one of the big
from
questions.
from the entirety of the document?
Well, that, as well as we've made at least, I mean, I think we've submitted we as a board then have submitted the comment that we would like to see some additional information in Chapter 11 to kind of provide a larger overview of the implementation, not just of these items, but of all the items that aren't in there. And just, so we've really two things. One, understand how that was made.
Okay.
And two, to ask, well, I mean, we're essentially, as a board, we're adding a comment to this matrix, asking them for that additional information.
Yes.
That's right, okay.
Does that answer your question?
It does. Thank you.
Any further comments? Discussion? Seeing none, all in favor signify by saying aye. Aye. All opposed, no. Motion carries. So that leaves the maps.
Mr. Chair, specifically the land use map from Chapter 3.
Oh, specifically that one, we don't really need to
We
address?
can go over the other ones, but sorry, I just assumed that you guys incorporated those comments as we went through each of those chapters, but we've never really discussed the land use proposals. And what I had done is, in the memo that I had sent you, is staff has come up with some areas of, that we want to look into a little bit more. And since there's over 40,000 lots in the county, we don't know viable and verse on every one. So kind of get from the commission which ones you're most concerned about, or even large subdivisions. We have 5 or 6 different subdivisions on our list that we want to look into a little bit more versus how Matrix has them, future land use zoning versus what we would like, because of soils now become a big topic. And then also some other comments that have come up from the city as far as when they're looking to expand their sewer and water. And do we really want to zone an area around the city that with high density that might not be getting sewer and water in the city's plan for the next 10 or 15 years? That's just a question, just something to put out there. So that was just a suggestion. The Planning Commission can look at all the maps if you'd like. That wouldn't be a problem.
All right, any comments on the future land use map, page 3-15?
Now, what I have on the board is, again, like mentioned at a previous meeting, the comprehensive plan future land use map is available on Rapid Map as a layer. And you can, as this comes directly from Commissioner Johnson's concern about the PDF version of it. This one on Rapid Map, you can zone in very closely down to the lot, just like you could with any others, and you can see what they're proposing as far as land use. Whereas on the PDF, you weren't able to do that. Now, this layer that you're seeing here was updated when the comprehensive plan was done, and that's July 2018. So any rezones specifically comprehensive plan amendments that were done after July 2018 are not incorporated in this, and we're not budgeted for matrix to make multiple changes over time as they're occurring. But we are going to incorporate those, and if staff has any issues, we'll bring them up. But we're looking at compatibility as far as current zoning and what the future zoning is going to be. So,
Mr. Chair.
Yes, go ahead, Rich.
There's some transition sizes where some dwelling units were in. I don't want to say no man's land, but we're probably grandfathered in, but not within the zoning, and maybe their zoning now will change from general ag to rural ranchette or some of these other scenarios that are probably going to happen. There's no automatic, will taxes be impacted by a change in zoning?
so from my experience and what we tell people, because we get that question quite often at the front desk, is zoning tells you how you can use your land. Taxes are based on how you do use your land. We have suburban residential zoned properties taxed as ag, and we have we have general ag properties taxed as residential in the county right now. So from what we're told from equalization, no.
Yeah, Mr. Chairman, if I can just.
Go ahead.
If I can just add on that, I've worked with the Director of Equalization in Rapid City for 35 years, and they don't take into consideration at all how property is zoned and whether or not the use of it is legal non-conforming, or flat out illegal. All they look at is how it is currently being used when they determine, and they do the Marshall and Swift calculation for cost and depreciation, et cetera.
And an additional thing, because there have been some questions about this, not necessarily with the Planning Commission, but I'll just put it out there, is when the comprehensive plan is approved with these zoning districts, the current zoning of properties will not automatically change. This is the future. So as as rezone questions are coming in, as new plats are coming in, then this will be the guide for the future. If people want to rezone to the current comprehensive plan, we're not going to be against that. In some cases, it'd actually be advantageous for them, depending on what the uses are. But current zonings will not change. This is the guide for the future. So as things change, we want to make sure we're in line with the future direction. So that was a misconception that we hear a lot, and I just wanted to make sure that I think you guys are all on the same page with that.
Well,
Thank you.
Mr. Chairman,
Yes, go ahead.
if that were true, or if it will be true, then anybody who adopts a new zoning will fall into spot zoning because nothing around it will be zoned with the new categories.
No, we haven't considered that, but I'll have to look into that, but they might be similar.
I see. All right.
They might be similar.
Just a comment,
That's really good. There are specific areas that we want to definitely target, the half acres subdivisions of general agriculture. Well, that's a 40-acre minimum. Those are some things that we want to address. And in like I said, in some subdivisions, it will actually benefit that subdivision, because right now, general ag is, in that one specifically, that's the least restrictive zoning that we have.
Yeah.
And so if it went down to kind of a ranchette or residential or something like that, it's a little bit more defined use and enjoyment area. So not necessarily sawmills next to a single-family residence like you could do right now.
So then with that, was there going to be an outreach at least to the community so that, for example, let's take a community that it happens to be in that half-acre general ag zone, and we want them to go to SRD or whatever we end up coming up with when it's all said and done. Is there going to be an outreach to those communities to say, look, we're not going to change it because we don't want to just change it, just to mess everybody up with what they're doing, but this is our proposal. Are you all interested as the community to transition to the new zoning?
Absolutely, and we're going to do it at our expense.
Okay.
Yep.
What happens if you get everybody but like 3 people?
What's that?
What happens if you get everybody in that community, but like 3 people, 3 properties?
We haven't thought about that part of it right
Okay.
now.
Well, there you go. Put that in your notes to think about. I'm
Right.
just wondering what's
But
gonna happen
we're
when.
looking at sending out the certified mailings, not necessarily return receipt, but the certified that it was mailed. And then let them know the proposal, but of course, there's always going to be the public hearing where people can come and express their concerns. But before we get to the public hearing, we'll make sure that we talked with the residents first.
Okay. Any other comments or questions?
Yeah,
Mr.
oh, go
I'm
ahead.
sorry, go
Go ahead, Rich.
I guess my question is, so how many properties, what's the workload look like from staff's perspective that you guys are going to be looking into? How many properties do you guys have concerns with that you need to revisit?
I'd say a safe estimate is probably a couple thousand.
Okay.
Thank you.
And mostly it's in subdivisions or?
But there's a few subdivisions, like I said, I got some here, Canyon Springs, Rushmore Ranch, Rockerville, Silver City, Hart Ranch. Hart Ranch is huge, it's a big PUD, but, I mean, there's a few hundred right there.
Mhm.
So, there's little spot ones, to use that word, here and there where, I think Matrix may have missed what the zoning should have been, and actually rezoned it backwards. And there's one right next to Ellsworth Air Force Base that by size and use should be residential, but they have it as an ag. So didn't really jive.
So then when you guys point these things out to Matrix, is that included within their budget then to make those revisions, or did I hear you say? Okay.
That's part of it. Yep.
So is it just you and your staff going through parcel by parcel, kind of zooming in at the map kind of systematically, like, or do you guys say, I'm taking this section, I'm taking this section, and?
Yep. So looking at it section by section,
Okay.
a lot of it, especially on the west side of the county, as you can see from the map there, that dark green. Right now on the current, here, I'll show you. And I'm too far away to be able to do it. Sorry, the map scale won't allow me to do it. But west of Rapid City right now, all that dark green is public lands. That's actually area that the county doesn't have jurisdiction in. If you look at our current zoning map, that's all light green. And so the misconception is our light green is general ag. And so people think that we actually have jurisdiction over that large part. So that area is going to be easy for us to do. But then and even if you go into the southeast side, there's going to be some public land that's going to be added down there. That's going to help cut down on those numbers that we have and add a little bit more of clarity. The tough part is going to be when we get to the zoning ordinance itself. Because as you know, the comp plan has made recommendations for 3 different distinct areas in the county, the east side, the central, and the west side, or the hills, basically. And so the zoning in those could be essentially the same color, the same name, but that in the zoning ordinance, it could have a specific list of uses different depending on where it is in the county. So we want to be a little bit more specific and a little bit more stringent around the city as they grow with their planning jurisdiction. So that's going to have whatever it is, the most restrictive ones, a little bit less restrictive over on the west side in the Hill City Keystone outlining areas, and then the least restrictive on the east side. That's at least the plan right now.
Yeah.
That was the intent moving forward and what was brought before the citizens during the public meetings.
And that's no different than city zoning, having a zoning regulation called general commercial, and county having a zoning called general commercial, and they are not the same.
Correct.
Yeah.
We're looking to get in line with,
Yeah.
because right now the county's outside border isn't changing. It's being slowly decreased from the inside as all the different towns and cities grow. And
Sure.
Rapid City being the number one that's growing the fastest. So we just want to make sure that we're compatible with them as they do grow.
So, PJ,
Yes, sir.
regarding PUDs,
Mhm.
they're, so remind us about, they've essentially gone away in terms of continued use of developing new PUDs. But the zoning, like let's say the blue on this map, that is existing PUDs that's already been zoned as PUD?
Correct.
are any of those existing PUDs, any of the blue, this is the future land use, but if we looked at the existing land use and mapped out the PUDs, are any of those PUDs going to be, is there a proposed change in zoning for the future land use?
No, right now we're planning to honor the existing PUD. And then if at some point somebody wants to dissolve the planned unit development, we would find the most appropriate zoning district to go into. The problem and the concern with PUDs is that every single one is different.
Right.
And
Okay.
they're essentially their own zoning district.
Yes, yeah, but, so the blue that's on the future land use plan is just those that have been zoned that way currently?
Correct.
Okay.
And do you not have PUD overlays on?
They're on here as well,
I see.
because that would be what the existing land use is.
Yeah.
Yep. So I guess that's a good statement. So if it is an overlay, which not all of them are,
Yeah.
then if that PUD went away, it would revert back. I think we
Yes.
just did one recently, and then I know the Hartshorns down by, across from Reptile Gardens is a PUD overlay. Yep.
Thanks.
Yep.
Anything further? Any other maps we want to address? Any issues? PJ, how many changes have already happened to that future land use map,
The one you're looking at?
roughly?
Oh, I can give you more than a rough here. Hold on, sorry.
What is it?
How many changes have already happened to the map
I see.
based on the items that we voted on that have come through?
I see.
Oh, maybe a dozen or more.
So there hasn't been that much change.
Too many. Large areas of land, if you notice that on that map, the large area of highway service or heavy industrial from Patrick Hall is not on here, and that's basically this whole area. So, I mean, so it may not be a lot, but some of them are fairly large parts of property.
Well, in the Highway 16, where it was general ag and now it's highway surface.
Correct.
For example.
Yep. Yep.
That's
Across from
true.
Rockerville.
Yep.
Yeah, there's a few, but,
Mm-hmm.
yeah, I mean, quite honestly, I have looked at the overlay and rapid map and to look at particular parcels, but it's just, I just don't feel at all adequate to really give much of a perspective on, individual parcels as to what they should be and,
But if there are any groups of areas, like we've even identified areas just we know the soils are bad. But if there's any areas like that we can look at and then go back and see what they're proposing as far as a zoning district. And then bring them forward as like an area of concern for public comment.
well, I mean, one area is that, I speak about it frequently, and that, there's not enough water in the Black Hills to sustain the development that's going on down back there. But thus far, that's never been reflected in any zoning, and there's not much we can do about it. But, I mean, like, for example, there's an area of bad soils. What are you going to do about it? There's area of low water. What are we going to do about it? I mean, so I guess I feel like, what can we do about it?
Yeah. Well, right now, one of the things, staff had went to a meeting over in the city, and in areas that are known like that, lower density. Don't do a high density zoning. Don't put it on as a future land use, do it larger density. So that's the type of an approach.
Well, we just did, that area by Keystone, that we just rezoned to allow 8 houses versus 4. I mean, and so we're doing it all the time. We collectively,
Right, no, I understand, yeah,
and
yep.
so,
But we can put it in here as a directive to slow
brief
it down,
it.
to stop it.
To let us know whenever you're doing staff briefings, hey, this is,
okay, well, I'll apply a little time and see if there's some areas that I think might work in that regard.
Or large areas, yeah.
Yeah.
Yep.
Gotcha, okay.
PJ, when was the last comprehensive plan adopted?
2013 was the last time it was updated.
Okay. And prior to that was
Oh, we go back to '03?
03? Okay. So it's been done on kind of a regular, consistent basis. But I presume, I don't know if I really have a question, but I presume that, even today, as some people come in and either replatting, rezoning, or whatever, that the land use may have been projected in 2003 or designed to be this use. It still goes back to prior to that, even on some of those that, I mean, just because there was a comprehensive plan adopted in 2003, updated in 2013, and so forth, doesn't mean that that land prior to that time has ever really changed.
Correct.
It still could be going back into the 1990s, 1980s even.
Yep,
as to
absolutely.
what it was designed for at that time. So comprehensive plans, I think, are hard to understand for the general public. And, they look at it and they say, oh, well, this is what is laid out for, is that, this is supposed to be, low-level density. But that may not be the way that it's zoned or ever has been zoned in the past.
Right.
And so, I mean, it's an ever-evolving type of situation that we're dealing with. I agree, a comprehensive plan is very necessary, but it's generally difficult for the public to really understand.
I would agree. From my experience and dealing with it for the last few years, absolutely, it is difficult. And if I wasn't in this, I don't know if I'd fully understand all of it either. Yeah. Yep. And that brings up, it just made me think of something also is, we do a lot of approvals of comprehensive plans now and rezones, and we've been keeping an eye on them over the last few years because that gives you a general idea of how the public wants to move. And Matrix has taken that into account. And our current zone, the current comprehensive plan land use does not fit with how land is being used right now. They always say, where's the best place to put a sidewalk? Look where the paths are. Kind of that same thing here, is look what the use is out there and see if it is the best fit for the county. So we've taken that into consideration as we're going, but also we fully intend that the week after the comprehensive plan is done and approved, someone's going to come in with a change. I mean, but it gives us the best guidance. We do anticipate, and we hope for fewer requests for comprehensive plans. I know we're not going to get everybody in the county to comment, but the goal is that people, if they want to do a rezone, that's one thing, but that we're going to have fewer comprehensive plans because hopefully the future land uses will match what they want to do. And then there also will be some type of financial forgiveness that staff will be allowed to just kind of go with that and not charge them the fee because they're coming into compliance with what we want them to be.
All right. Any further comments? Pardon me. Swallowed down the wrong tube. What do you need from us at this point? Do we just need to approve some of the changes that are already on this map, or is that all inclusive in what we've done?
Well, that was going to be my question, is I can come back at the next meeting with the answers from Matrix to the questions about Chapter 11. And then also, if there's any areas, if the commission wants to take the next 2 weeks to kind of look at the map and see if there are any areas or properties or developmental areas that they have a concern about, and address those. If not, we can kind of leave it as is. I can send what we have off to Matrix. They can get that process started. And then after that's done, with the edited version, it can come back before the Planning Commission for a final review. But again, knowing that this still has to go to the board for the same process. So you can do another week, or I can start processing everything over to Matrix now.
Mr. Chair?
Yes.
Are you and staff ready to send your comments to Matrix with respect to your concerns that you guys have found in the map?
We've been making comments, well, we've made comments earlier on, even before drafts that you have seen.
Okay.
But new comments have come up. They're just going to go in the same time yours do.
Okay. I don't have specific ones. I mean, I kind of see this as if staff has already gone through and reviewed the current versus future and done that section by section, I don't see myself going through and doing that specifically to the extent that staff has. So I'd be in favor of moving this forward to Matrix to keep it moving forward.
Just to clarify, staff hasn't done that yet. We've pulled out specific areas.
Okay.
But we haven't really done a target. I think that's the plan.
Okay.
But we wanted to see what the commission was thinking before we devoted time to it. Sorry if I misspoke that.
No, I just, you know, here's what I think needs to happen is there needs to be a error check, so to say. If they've done something adjacent to Ellsworth, for example, that the example that you gave, where it's like that makes zero sense. I mean, you guys probably are going to notice that much quicker than we necessarily would, and so I would like to. I guess as long as that's happened and that can get to them, that's the next step I see is giving them final comments and letting them come back. But can those things happen at the same time, or do they only want a group of comments and then returning with the final?
If we can just send everything to them at one time, it's better. We're getting close on the budget with them, and they still have a whole other series of meetings and one more presentation before the board. So if we can send everything to them at one time, that would be the best thing to do.
So then I mean, is that, this is an exercise your staff was going to go through is cross-checking the map?
Best we can, yes.
Okay. How long do you think it'll take to do that?
I'd give it at least 2 weeks,
Okay.
and that's on and off.
So then maybe we,
The east side is not what we have to worry about so much. It's the center and the west side.
okay. So maybe we give it 2 weeks then, and then in 2 weeks we send this off to Matrix. I don't know.
I'm okay with that.
I'm just,
Do we need to readdress anything? I don't feel that we do at this point in time. I think most of us have put our comments in and there are certain things we want to address or we've made changes or whatnot. I mean,
and there's been a lot of errors found, in the document, and I think all of those were noted during the discussions, and so I think that those comments have already been received and probably put on the list. My concern is the ones where what got done doesn't make sense and should be reviewed further.
And most of those we anticipate around the city and around the populated areas in the Black Hills. But again, the Black Hills, most of that area, which is a lot of change, most of it's public land and not even something we have to look at.
Okay.
And
go ahead.
And so, I mean, I'm fine with doing what we need to do to move chapter 3 off our agenda. But I mean, the opportunity, as I understand it, is available for any of us as citizens of the residents of the county to submit comments. Like, for example, if I go home and I start, zooming around there and I find something that I think I can submit a comment.
Absolutely.
So, I mean, we're still not precluded from
Right.
submitting a comment or two if we choose to drill down a bit. So I'm fine with moving 3 off of our agenda.
Mr. Chair.
Yes, sir.
I think, what the Planning Commission has done with this, I think is remarkable. You've done a lot of work on it. And I would also just remind you that this will come before the board again too. So if there's things that are caught between now and that time, the board is certainly going to be welcome to hear anything from Planning Commission members as to suggestions, changes, whatever, too. So I wouldn't be overly concerned about making sure that, every I is dotted and T crossed before you move it on, because I think those things will be caught
Right.
eventually. So,
Well said.
All right. So then we just need to make a motion to move it forward with the staff's comments then? Is that really what needs to be done?
Yep.
Move it forward to Matrix with staff's comments. At the same time, you send staff comments.
Because you're still going to see the document coming back, and then you're going to make the final recommendation to the board at that time.
Right. Correct.
Yep.
All right. I would entertain a motion as said to
I'll second.
Motion and second. Any further discussion? Seeing none, all in favor signify by saying aye. Aye. All opposed, no. Motion carries.
Who made the first motion to move approval?
Who motioned it?
Yeah.
I did.
Rich.
And then we need a motion to continue it to the June 10th meeting because that's what it's advertised for. Because it's an ordinance amendment.
Okay, so even though we don't plan on addressing it, we still gotta move it to that meeting, but that way we can still take public comment.
Right, yes.
All right, so what's the motion, Terry?
To continue the ordinance amendment to the June 10th Planning Commission meeting. And I didn't know if you guys wanted to put on the language and if needed, to the June 24th meeting. Right now, it's only been advertised to the June 10th meeting.
I don't think we need to go any further than the June 10th. Does anyone else have a need or necessary?
Not until we have an idea from Matrix how long it's gonna take them.
Right, so I think we could just do the final meeting on the 10th, and go from there.
Though it would only be if needed to say for the next meeting as well, so we don't have to, right?
That's
Isn't it-
up to you guys if you want to add that June 24th meeting in there.
It's only an if.
I'm
needed.
okay either way. But wouldn't it be submitted to Matrix prior to then? If you said
Yes.
you just need it in 2 weeks.
Yeah, so let me get this straight. So the reason that they have to address the next one is because it's been advertised already.
Right, and and it's an ordinance amendment from Pennington County.
Right.
So you will either deny or approve your ordinance amendment at this.
Not
June
that,
10th.
not on that date.
So then you're gonna have to have it heard again then.
Correct. And I believe we know that. So on that June 10th date, we'll have a better idea how long it's going to take Matrix.
Okay.
And then on that date, you can set the review date
The
for the
review date.
final review.
Right.
So
Should
I don't
we
think we
put-
need anything after that next meeting.
We
Yeah,
put something in there, final review, just to be safe? No?
Well,
I wouldn't hold,
Okay,
if you want to hold yourself to it on the agenda, you could put that in there, but we haven't
Okay.
put that on so far.
all right.
Like I said, we'll be sending it out, having it in the paper and trying to get, as many people involved as possible, so.
So I'll move to continue the ordinance amendment 1901 to the June 10th meeting for consideration of the plan. Consideration of the plan. Is that sufficient?
yeah, that's fine.
Second.
Motion second, any discussion? All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. That takes us to item number 22.
Item 22, County Board Report. The Board of Commissioners concurred with the Planning Commission's recommendations from the May 13th, 2019 Planning Commission meeting.
Any questions for PJ? All right, item 23, items from the public. Any members of the public like to speak? I see none. Item 24, items from the staff.
There's more than two.
I figured as much. That's a standard operating procedure.
Yep, that's our SOP. The item A, ordinance officer interviews. As you know, we have requested if the planning commissioner is interested in joining or being part of those interviews. We have first round interviews tomorrow. We kind of have the committee for that. Second round interviews are scheduled for June 6th. So if anybody is interested in being part of that, please let me or Cassie know.
And what are you hiring for? What?
This is ordinance officer. Amanda went to do a job over in School of Mines.
I see.
I was gonna say, didn't we just get one?
She was here less than 4 months.
Ah. Any complaints on her part?
Not that I'm aware of. What she told staff upstairs was it's a considerable amount more money with less work.
I see. Oh,
Well, there you go.
Foolish girl.
I said I would take it too if that was the case. All right, item B, Planning Commission membership interviews. As you know, I believe it's Commissioner Lassiter and Commissioner Marsh are finishing up their term in June. And there are interviews coming up for the applicants. And that is being held on the 29th, so tomorrow morning. Yep. So what happens at that, there's a recommendation from that interview panel is then brought before the Board of Commissioners, and then the Board of Commissioners makes a determination and appointment at that meeting, as you've all been through the process.
How many people have applied for that?
6.
Oh,
Well, I think it's 6 to 8.
Wow.
who's the members of the interview committee?
As far as I understand right now, it's just myself and Ron Ross Connect.
So
It's just a recommendation committee.
yeah, but it's just two people?
That's my understanding. We're not heading it up.
Oh.
I'm just to show up pretty much.
I see, okay,
But,
all right,
So it's not
not
before the
getting
whole
them,
board as it was in the
fine,
past.
yeah.
no, the people that will meet with the applicants make a recommendation to the board. The board still makes the final decision.
Gotcha.
And who amongst us is being replaced?
Commissioner Lassiter and Commissioner Marsh, so.
Or we could be replaced. We could be,
replaced.
we could
Yeah.
be reappointed.
Their they fulfilled their time at the end of June.
Term is ending.
So our term is ended,
You could get a
and
new term.
I have applied for a a new second
Okay.
term, but, yeah, so you might see me, you might not.
Okay.
Just two quick items I wrote down. One of them is to address something from Commissioner Marsh that he brought up earlier about the RVs being used, while people are building residences. Staff has actually cut down on the amount of time. Some of them, for those who have been here for a long time, have gone on for 12 years. And where they didn't use necessarily an RV, but they used a caboose as living quarters while they were building a residence. And so we are cutting down considerably on the amount of time and not allowing them to just go on and on and on and on.
No, I think that's great. One of my concerns is the CUPs that come up, these a little bit outside of the rule things where it's like, okay, that's okay, but these issues then require staff to be reviewing these issues every 6 months, every year, or whatever the time frame is on there. And I suspect that the time and the money it takes to actually go out, do the site visit, review that they're doing what they said they were going to do, and then not putting a time stipulation on them to measure them to make sure that they're indeed doing what they said they were going to do probably doesn't pencil out in the county's favor. And so I just see that if that number continues to grow, we're setting ourselves up for an issue.
Yeah. With conditional use permits, there is a $100 review fee only for vacation home rentals. There are some other permits we have, not CUPs, that require a review fee. Like if TJ or an on-site wastewater specialist was go out to a property and they weren't ready and he had to go back out again, there's a fee for him to travel. We've estimated 1 hour of staff time costs about $65.
Yeah,
Kind of an average.
that sounds about
with
right.
insurance and everything, but we absolutely understand what you're saying as far as having to go out repeated times. There are many times a $300 permit doesn't even cover, the paper that we've printed for the meetings that have a hearing
Right.
sometimes,
Well, and it extrapolates because as CUPs go up, now all of a sudden the time frame at these meetings is going to increase. Potential issues that staff are running into increases, ordinance officers. I mean, so I don't know. It would be good if we could all operate within our zoning.
Right. And with one of staff's notes for the new zoning ordinance is to have more things administrative. We still will definitely have a need for the planning commission, but to be able to take some more things, kind of just take them upstairs. And even some parts of the plating process for that matter. The other thing is there was a comment from Commissioner Rundy about that condition that goes on the layout plats, that this doesn't constitute. In the past, we've had a few examples of people, again, they don't understand the process as we've explained it to them. And they think that that's it. There's no other hearings after the layout. And then they make a purchase or buy materials for a building or something like that. So we do what we can to kind of put it in there. But as you've heard through the construction permits, just because it's in there doesn't mean that everybody sees it.
Yeah.
But we do what we can.
But to me, with the signature, I mean, people sign leases and later on, I didn't understand what was in the lease. Well,
Yes.
that's no excuse. Ignorance of the law is
Right.
Right.
no excuse.
But that's it. I just wanted to address those two things with a little more information. But nothing further.
All right. Any items from the membership?
It's been another fun month.
Well, glad you had
I'll
fun.
probably be back in October.
No, probably not.
All right. Anything else from the membership? If not, I'd entertain a motion for adjournment.
So moved.
Second.
Motion and seconded. All in favor signify by saying aye.
Aye.
All opposed, no. Motion carries. We are adjourned. Thank you, guys. It was
Thank
fun.
you, everyone. Yep, great conversation.